Thank you to everybody, particularly all the staff back at Fenners who've helped out. The very practical announcement is that I'm told by people they're not expecting a fire alarm practice today. So if the alarm goes, it is real. Please exit via the nearest door. I'm not going to do the air hostess bit because I'll drop things. But the meeting point is near the plaza just that way, so if everybody could gather there, and because we've all had to sign in, please don't leave without telling somebody that you're leaving, otherwise we'll be coming back into the building to look for you. So I think that was everything I needed to say from a practical point of view. We're going to have a couple of talks first, and then a coffee break. First coffee break's at 11:15. And the first talk is by Penny Grucock and Lisa Hannant at Fenners, and they're going to do a public law update. That went well.
I'm just going to get rid of the defunct microphone. Yes, so you have Lisa and I today separating this up to try and keep it even more interesting. However, we thought we'd split it and have less work to do for each other, but typically I think we may have just kept the same workload and we're going to have to get through it quite quickly. Okay. It's the next issue with the tech. Trying to get you a slide. Okay, it looks like I'm going to have to do this by hand. So, case law update. Interim separation. This was an interesting one where the parents had been in a residential unit for 8 months by the time this came up. They were two parents who had learning difficulties. They'd gone straight into the residential unit. Well, mum had been in a mother and baby for 3 weeks. Both parents had intermediaries. Dad was represented by the OS. They'd already had 9 children removed from their care. And Dad had a conviction for hitting one of them. The residential assessment concluded, perhaps unsurprisingly, that they couldn't do it in the long term. But the question was, what do we do between now and the final hearing? The local authority applied for interim removal pending that final hearing, but the court at first instance allowed the parents to remain there on the basis that no immediate harm would be coming to see because he was in a residential unit. The local authority appealed that, and the Court of Appeal agreed with the local authority. Well, they remitted it for a rehearing, but they agreed it needed to be looked at again. They said that the court had relied very heavily on RECs. That's our nice 5-point test that we all like to use. But what the court hadn't done was to undertake a proper balancing exercise outside of that, focused on the welfare for the child. And that the question for the judge should have been whether the concerns from the unit taken all together and attaching paramount consideration to the welfare met the high standard of justification required to render necessary and proportionate interim separation. It said that the judgment that was given in relation to the child remaining in the residential unit hadn't contained an anxious consideration of the issues in the case, nor a coherent assessment of the evidence filed, and that there were no indicators in the judgment as to what matters the judge had actually taken into account in performing a balancing act. And that perhaps what the court should have done was to look a bit more at what the emotional needs were of the child and whether that could result in harm. So that was remitted back. So it's a case effectively that says just because they're not going to come to immediate physical harm, you really do need to seriously look at if they're finishing the residential assessment. Scope of a fact find. Very sad case where mum's first baby had died. Nobody had litigated why that had come to pass. He had died from fatal brain injuries. The working assumption was that mum had perhaps lost control and shaken the baby, but there were no findings in relation to that. The police hadn't taken it any further. The local authority hadn't taken it any further because she had, at that point, no other children. 7 years down the line, she has another baby. And the local authority became involved due to concerns about her mental health, her drug use, and her hostility towards professionals. Mum and baby had gone into a residential unit, and that residential unit had ended up with a positive report. And at the time of the hearing, baby was still in mum's care, and the plan wasn't to separate them at that point. But the question came, before we get to this final hearing, what do we do about the sibling? Do we need to have a fact find to work out, is mum culpable or not of that? The argument for obviously seeking a fact find is that because the court is required to assess risk based on proven facts and not assumptions or suspicions, should the judge find that the risks to G could not be, would the judge find the risk to G couldn't be properly assessed without determination of the mother's capability or not? So that was the question. Can we do it without a fact find or not? So initially, it was thought there should be a fact find, but the Court of Appeal said, the local authority sought for there to be a fact find, but the judge said one wasn't needed, and the Court of Appeal agreed with that. It said that, taken its highest, if mum was responsible for the initial death, then it looked like it was a result of an impulsive shaking event. It wasn't a single issue case. There were other issues which the local authority was still concerned about, so her mental health, her drug use, and her interaction with professionals. And the Court of Appeal said, the local authority would be in care planning in any event without knowing about this, and the care plan at the moment is not to separate. So what actually is this fact find going to add to the case? How is it going to take the case forwards? It's 7 years later. Are we really going to be able to work out what happened? It might set out more in relation to the medical facts, but will a fact find actually lead us to know what happened? And the risks that there may have been in relation to harm coming to the child were in relation to mum's impulsivity, taking it at its highest. And that could be assessed, said the court, by looking at how mum was now with this particular child, and that it wasn't actually going to move the case on. So the Court of Appeal agreed that they didn't need a fact-finding in that case. So even though it's a really serious matter, and you think there's a death of a child, we've got to look into that. How is it actually going to be helpful and move the case forward? Particularly, as I say, in this case, the plan was, regardless of what the outcome was, it looked like at that point in time, baby was still going to be staying with mum. So threshold findings. So, local case. So in this case, the parents hadn't turned up at the RH, they hadn't engaged in assessment, and they hadn't been cooperating with the local authority. Dad hadn't been attending much contact. They didn't come to the RH. There was an order earlier that said if the parents didn't respond to the final threshold, then they would be deemed to have accepted it on the basis that the local authority had drafted it, and that the court could make orders at IRH if they didn't attend. So the court was asked to make orders at IRH, and they did make orders, leading to care and placement orders, where threshold was deemed to be met. This was appealed on the basis that, the parents weren't there, so they appealed. The Court of Appeal said that they disapproved of the common case management practice supported by the standard template that we all had at the time, which said, effectively, if they don't respond, deem it as met. That regardless of that, the court needs to consider the threshold itself. The judgment needs to look into what the actual facts are, how the evidence within there meets those facts based on the evidence that's there, and to make actual findings. It also, this case then led to a review of the draft orders the standard orders that we have, and in May 2026, new orders came out so that it now reads, if the parents fail to respond, the court may proceed to consider at the next hearing whether the Section 31 threshold criteria are established by reference to the written evidence filed by the local authority. So it's just a case, well, A, make sure you've got templates are up to date, and B, make sure even if the parents haven't attended, they haven't done what they're supposed to do, we need to make sure we look carefully at the threshold criteria, not just make an assumption about it. So in this case, this was about notification of Dad as to the proceedings. Mum had made allegations of domestic violence against Dad. Dad was in prison, not for anything related to Mum, but for some pretty nasty offences. Mum was in a residential unit with baby, and she was doing quite well, and she really didn't want Dad to be notified of the proceedings. She was very anxious because she said she was a victim of domestic abuse. She was worried that letting him know about the proceedings and becoming involved would lead to him exerting more control over her. And she was also made the point that she was doing relatively well at the residential assessment, and she was worried that him knowing would undermine that because she'd get so anxious and she wouldn't be able to put forward a good case. However, on the other side of that is the fact that this is a case where Dad had PR, he was on the birth certificate, so you'd need compelling reasons not to notify him because he's an automatic party. He did know of the child's existence, he'd already met her, he knew that the local authority were involved in some way, not that they'd issue proceedings, but they're involved in some way. And the guardian was particularly anxious that by not giving Dad notice, that meant that the paternal family wouldn't be able to be considered as potential carers. The court's decision was that Dad should be notified, and that the risks to Mum could be managed through things like giving him notice but no further papers, and then if he did want to become involved, looking at what sort of papers there should be. So it's a case that also sets out the law quite nicely. So if you've got one of these cases, it's an easy case to go to see where everything's pulled together. I must say the cases I've done where we haven't notified tend to have been ones where Dad doesn't know about the existence of the child, the ones where we've been successful anyway, where Dad doesn't know about the existence of the child, and that would set off a whole chain of events. So this is about making final orders at IRH. So we've already had one, this is a second one. This is one that no doubt would have been sending their local DFJ a little bit crazy in relation to statistics, because it was at week 128 by the time it got to IRH, with a bundle of over 1,700 pages. The children had been living with Dad during the proceedings, but at the time of the IRH, were now living in two separate placements with family. And at the IRH, the local authority asked the court to make final orders. However, that hadn't been their case when they had arrived. Their case summary had said that the matter should be listed for final hearing. So it was a bit of a change of circumstances for everybody pitching up to court that day. The parents obviously opposed that. They didn't want orders to be made at IRH, but the judge went on to hear brief submissions and went on to make final care orders, but with a plan of the children remaining with family. But there was something important missing. The special guardianship assessment hadn't yet been completed, so the plan was that they'd stay there under final care order, and at some point in time, the local authority would support the family to make special guardianship orders. The parents appealed that. They wanted to have their say, and the court found that the Court of Appeal found that whilst it was understandable that a judge would want to finish the matter at week 128, that we can't finish matters at the expense of procedural fairness and justice. That in this particular case, there had actually been a material fact to be tried, and that was because Dad said the children should return to him, and that fact we needed to look at was the future risk to Dad, of Dad, dependent on the changes that he had or had not made. So Dad had said that he had come off the drugs and he was maintaining that. Social workers' view was that he hadn't made the sufficient changes, and the Court of Appeal said that's a material fact that Dad had the right to be litigated. And that it had been unfair on the parents of the local authority to change their stance at that hearing. It was a big change to go from everybody thinking you're going to set it down for a final hearing to suddenly having to make submissions about whether or not final care orders are going to be made. The Court of Appeal was also concerned that they'd done that when evidence was incomplete. The filing dates for further evidence hadn't passed at that point. So the court didn't actually have all the evidence which it had previously deemed necessary for it to have by the time it got to a final hearing. The court was also worried that when the judge had made her order for care orders, what she hadn't, within her judgment, looked at carefully was contact. It meant that Dad's contact was going down from once a week to 4 times a year, and more significantly, the children's contact was being reduced from 3 times a week with each other to 4 times a year. And the Court of Appeal were very critical of the fact that the judge at RH hadn't looked into that. They also gave us a nice little 5-point test. If you were going to be looking at concluding at RH rather than final hearing, the court needed to address some issues. Firstly, why are you using the RH as a final hearing? That needed to be set out in judgment and justified. You needed to address threshold specifically and the evidence which supported it. It was another one of those cases where the parents hadn't necessarily, they hadn't responded because I don't think not all the evidence was in. It hadn't been deemed to pass threshold. It wasn't really a threshold case, though. Discussion of, and I think that's the reason the judge had given, actually, now I'm thinking about having said that, but they said, regardless, you need to assess it properly. You need to make sure, even if it's being dealt with at an RH and it's being dealt with, therefore, much more quickly, there needs to be the proper balancing exercise of all the options for the children. That hadn't been in there. The court needs to make sure they address the welfare checklist in detail, and it must consider anxiously contact. So all the things you'd have at a final hearing, but they said you need to make sure you do that very carefully if you're finishing at an IRH. So, and the court referred us back to Re-J, which said that orders that contemplate final orders should only be made at RH if all the necessary evidence was before it. So that's your evidence, if that's your case if you need it. This case, and Re-J, if somebody's trying to finish at RH without all the evidence being filed. I've got a couple of care orders at home. They're not things that we tend to see very often, but there are some places it seems to be more popular looking at the case law. So in this case, the question was, should the child was going to remain with mum and dad. But the question was, is that going to be under a supervision order or is that going to be under a care order? At the point of the final hearing, both parents were still using cannabis. Dad had diagnosis of ADH. And he was struggling with that, but it was said, the assessment was that mum was managing to make up for those deficits. But there was a concern about how Dad, being a first-time parent, his cannabis use and the medication from his ADH, how all that was going to be interacting. The local authority and the guardian sought a care order at home because they were worried about the risk emanating from the parenting of the parents. They said it was still too high for them to step away, but they wanted the child to remain with mum and dad. And the local authority said there was still quite a lot of work that they wanted to do with the parents, and they needed to do that over a longer period of time. That work had been recommended by an ISW. The parents didn't want a care order at home. They said supervision order will do fine, thank you very much. We can do all that work under a supervision order, it doesn't need to be under a care order. And they said, baby's already transitioned back into our care, so surely we must have made improvements and reduced risk if you've let the baby come back to our care. He'd been home 7 days by the time of the final hearing. So this is a case at first instance, and the court looked at the public law working group recommendations about care orders at home, and they said they recognised that it needed to be exceptional reasons if you're going to have care order at home, made it clear that you can't use it as a vehicle for provision of services and support, and that placements with parents needed to be evidence to comply with the placement with parent regs, and that it would be rare in the extreme that a child would be placed at home under a care order if it was thought that the risk was so high that they need to be managed under a care order in the first place. Having said that, though, they did endorse a care order at home. They said that's because the risks on the ground to baby remained a medium to high level, and that emanated from the parents' own challenges. As I talked about, dad's ADHD, first-time parent, medication, cannabis use, and that an expert had recommended that dad needed careful management and support and be able to care for Q. And this was a dynamic risk that was moving up and down. And therefore, the local authority thought the court needed the ability to manage that calibration of risk. So is it looking higher? How do we bring that down? Everything's fine now. Oh, it's gone higher again. How do we bring that down? And that work still needs to be delivered with the parents. And so the court made this care order at home because they said it was the only way that risk could in reality be managed. and that if the child continued to be subject to a care order, with the local authority fully on board and fully engaged in monitoring the safety expectations in his day-to-day life, that would keep him safe at home. And so, therefore, it wasn't, on the court's current analysis of risk, acceptable for the local authority to step away under a supervision order. So, exceptional circumstances that you need to have a care order at home. In that case, it was this sort of dynamic risk of keeping an eye on things. But obviously, they'd made the decision that the baby was staying there and they needed a way of keeping it safe. And the court thought hands-on was the better way forwards for that. This is one which the title doesn't give much away for. So this is a final care order that had been made at a final hearing, obviously, where the local authority had not wanted a care order to be made. So there were 5 children. They'd been known to the local authority for over a decade. The local authority's final evidence initially was that they should remain at home under a care order. As I say, clearly more popular at other places. However, 4th day into the hearing, everything starts to change. Mum's given evidence, and Mum is quite adamant that she's not going to work with anybody and that she doesn't want to let social workers into our home. So the local authority changed their plan. The plan is now that there should be a separation, and the plan is to separate the children over 3 different placements. Obviously, the parents then say, we'd quite fancy having them home, thanks, and we won't have an order. However, the judge went on to make care orders at home and told the local authority to file some updated care plans a bit later on. Local authority appealed, went to the Court of Appeal, and the way they dealt with it was they'd recognised something else, which is the fact that the court had gone on to make these final care orders without actually having a Section 31 plan before them, didn't have a care plan. And that was a fundamental flaw because the court has to consider a care plan when it's making final care orders. Therefore, it wasn't lawful for the judge to make those orders, and the fact was that the judge should have adjourned it and invited the local authority to reconsider its plan in light of her judgment. So that matter was remitted for rehearing. So it's just a reminder that you can't go around making care orders without a care plan, and the local authority needs to have a chance to look at it, consider it. I know we've got a lot of case law back on that from quite a while ago, but it's just a reminder that that's there still happening. I've got two proportionality ones coming up now. So this is placement order proportionality. So this mum was a Japanese national. She was, I think she was 56, it says, and she was a professional. And the local authority described it as quite a complex case when they were doing the case. They'd been involved since birth. She had an unusual presentation, Mum. There was a consideration as to whether or not she might be neurodivergent, but the case doesn't particularly go into that. But there were some concerns about that and how to help her and manage her. The case had taken 21 months by the time it got to the end. And during that time, Mum and baby had been together all the time. They'd been at 3 different placements together. And the question was, what do we do? And the local authority had sought to have baby removed, care orders and placement orders. Mum appealed that. She said, we've been together all this time and we should continue to be together. The Court of Appeal classified this as a case where they said that the feared harm had not yet materialised. So there were no harm had come to baby whilst they were there, but the way in which Mum had interacted with professionals, her insight had led the social workers to determine that they were concerned that there was a risk of future harm to the baby. But the Court of Appeal said this is a case where feared harm has not yet materialised and might not, in fact, ever do so. Mum had been primary carer for nearly 2 years, they said, during which no harm had come to the baby. The consequences to N of accidental accidents due to Mum's inattention to risk was no worse than the consequences to any other child, they said. So linking the proportionality of the harm. So whilst Mum might not necessarily be able to see what was coming up and she was inattentive in relation to risk, what was the actual magnitude of the harm that would arise? Is it for this particular child any bigger than any other parent? They said that parents do lose attention, children do have accidents. How is the consequence of that harm to this child any bigger than to any others? Court of Appeal agreed that mum had reacted poorly to direct parenting advice, but they pointed out her case was she was a professional, she'd been working whilst in the placements, working from home, and her plan was that if the baby was returned to her care, that she'd have childcare or a nanny or a childminder, the baby would be going to nursery or school. The Court of Appeal were critical that hadn't been considered by the social worker when the recommendation had been that mum would need 24/7 support. The Court of Appeal didn't view that she would actually need 24/7 support, and they said there was no evidence mum wouldn't abide by rules that set for her, because while she was a bit tricky with professionals and had reacted poorly to parenting advice, if they gave her rules, the evidence was over those 21 months she had stuck to them. The recorder at first instance had emphasised there was a likelihood of emotional harm because of mum's emotional dysregulation. There were 3 particular incidents that they'd referred to where mum had got cross with a social worker, mum had sort of shoved baby into a foster carer's arms, another time where she'd lost her temper. There were other things, but they were the 3 that had sort of made it into particular consideration. But the Court of Appeal said that baby hadn't actually suffered any apparent harm from those incidents relied on, and it was hard to see these issues as a major factor, and that many children do have difficult parents. Many children do grow up surrounded by conflict. But it had to be demonstrated, and wasn't in this case, that that kind of behaviour would translate into harm for Elle. So, again, one of those cases that says children do have difficult times, we can't protect them from everything, and it's a proportionality you have to look at. Now, they also said, what we'd like to do is to substitute these care and placement orders for a supervision order, mum at home, baby at home with mum, but at the end of the initial proceedings, mum and baby had been immediately separated. It had been 3 months. Mum, for some reason, hadn't applied for a stay. She'd had no contact. So it was going to have to go, it was actually remitted back for a further hearing because the court said there's work to be done on rebuilding that relationship. There's been no contact for 3 months, and we don't know what the situation is at the moment. So sort of, a bit sad, really, that that's what they thought should have happened, and then they weren't able to do it. So again, it's about, as I say, it's about proportionality. There are risks to children, the risks that we identify and look at, but what is the magnitude of that risk? Where is the proportionality? If you're making care and placement orders, it's a really big thing to be doing. Can those risks be managed? Are they actually risks that are going to be occurring for other children? Is there anything that's worse for this particular child than some other child whose parent might be texting on their phone whilst they fall off the slide or something at a play park? What is the magnitude of those risks? And is there anything you can do to bring that, to help with that? Proportionality again. So in this case, there were 3 children. They'd been in their grandparents' care all the way throughout proceedings. But there had been a risk, said the local authority, due to a risk of sexual harm. And this was because Grandad did have historic convictions from 40 years ago. And then there were 2 sexual incidents involving an uncle approximately 10 to 18 years ago. So in this case, the court had initially made care orders, but that was appealed. The appeal focused on the risk assessment that had been undertaken by the recorder, because the recorder had placed quite a lot of weight on these risks of potential sexual harm to the children. The court said you've got to look at, the recorder at that point in time had looked at unproven matters. Things, so I say, in relation to the uncle, there were allegations, but they weren't convictions, they weren't proven. They weren't litigated within these proceedings either. In fact, actually, uncle had come to give evidence and he'd been stood down. So he was happy for his evidence to be tested, but the court had decided that that wasn't necessary. So the Court of Appeal substituted care orders for supervision orders, and they had to look out why did they do that. So the Court of Appeal said Grandad did have historic convictions from 75, 78 and 84. As I said, Uncle got no convictions, but there were these allegations. Everybody had very sensibly got a risk assessment in the proceedings, and that risk assessment had come out as being very low to Grandad and to Uncle. And the key focus of the appeal was about the risk analysis they had to carry out, but also the factual basis on which that risk analysis was taken. Again, the court saying proportionality-wise, risk is part of, the Court of Appeal said the risk is part of life, and everyone is entitled to choose the level of risk that is acceptable to them. However, courts have to adhere to the legal principles governing risk assessment in the context of which they're working. So if there is a child likely to suffer harm, is there a real possibility, and a possibility that cannot sensibly be ignored, having regard to the nature and gravity of the feared harm? That's something we all know. The court's conclusions must be based on facts, and that facts are evidence of which a court can be judicially satisfied to the requisite standard of proof. Again, sounds pretty standard, we should know that. And that a decision by a court as to the likelihood of future harm happening must be founded on a basis of present facts, and the inferences to be drawn therefrom and not from unresolved judicial doubts and suspicions. And that was the concern that happened at first instance. There'd been unresolved judicial doubts and suspicions. They said, if the case is based on a likelihood of future harm, then the court has to be satisfied on the balance of probabilities that the facts on which you're balancing that prediction did actually happen. It's not enough that they may have done so, or that there was a real possibility that this happened. You need to take time to prove the contested matters. And the fact that saying it's going to take us too long to go through that, is it really necessary? If you want to rely on it, you're going to have to take the time to prove it. If you don't want to take the time to prove it, you can't rely on it. The Court of Appeal was concerned that the recorder had made repeated references in the judgment to patterns of repeat behaviour, things not being able to ignore things, and the behaviour of the uncle. The Court of Appeal was critical of that because they say it showed a lack of any appreciation of the distinction between facts and allegations, and specifically suggested it was clear that recorder was influenced in her assessment by matters that had not been proven or even investigated. In that, she was talking about the uncle who'd had these allegations made, the fact that there was a risk, they said, because these allegations were made against him. The Court of Appeal says they're not proven facts. They're suspicions, that you can't base your risk assessment on that. As I said, they were very concerned as well, as I said, that the uncle had arrived and not actually being tested in his evidence. Everybody had said he didn't need to do that. The Court of Appeal said that while sex abuse is clearly a great evil, but the court's function is not to protect children from all risk at any price. Overall, they were left with the sense that the recorder considered that any significance for these children being sexually abused in the home arose from a combination of historic facts and a lack of protective instincts, and that must have led to removal. That unduly privileged one factor, said the Court of Appeal, in the welfare checklist. So that concern about a risk of future harm, sexual harm, the Court of Appeal felt had not been balanced properly with all the other positives that had been by the children who had already been in their grandparents' care. So again, as I say, that is about proportionality. And then finally, this is a case where the local authority ended up paying Grandma's legal costs in the sum of almost £16,000. So in this case, there'd been first child adopted, second child was born within those proceedings, and that baby had gone into the same placement as the adopted sibling, and they'd been there for quite a period of time, 13 months by the time of the hearing. Quite a long way through the hearing, Grandma turns up, says, I've just found out about this case. I'd like to be assessed, please. She does have a positive assessment. So at the final hearing, the court was looking at balancing Grandma versus care and placement orders with baby staying with the sibling. The court went on to make care and placement orders, keeping baby with sibling, but that wasn't without a heavy criticism of the local authority. The reason that the baby ended up, the preference was for care and placement orders, was that the court had to balance the benefits of growing up in the family with grandma, but missing out on that sibling relationship, or maintaining the sibling relationship, which he'd already had for 13 months by that point in time, and having contact with grandma. And the court, in this particular case, came down on maintaining that sibling relationship and ordering monthly contact. But what's this about costs? So why did that come about? And that is because the local authority were criticised for not finding grandma, effectively. So mum with the first child hadn't put anybody forward, and they hadn't looked at anybody else. Second time it comes around, mum again puts nobody forward. But looking back through the files, and it transpired that the local authority had known that grandma existed. They had known roughly where she'd lived, and they'd actually known that before the first child, the placement order was made. But what the local authority hadn't done in this case had gone to grandma themselves. They'd said, mum hasn't put them forward, we're ignoring that. There's a whole interesting little thing in here about who knew what when, and it's a bit like a detective novel if you've got some extra time. Who did know what, who knew it when, and when should they have known. But it was common knowledge amongst everybody that they all agreed that had grandma been informed about it at the outset of the proceedings, baby probably would have been placed with her, and that it was quite likely, if you hadn't built that sibling bond, he might have ended up with her. And then the local authority, they didn't object, so there's no ruling about why they had to pay it. The local authority didn't oppose paying grandma's costs in this particular case, because she'd had to represent herself throughout it. So it's just one of those cases. It's something I know I tend to bang on about, which is that just because the parents haven't put a family member forward, you've got to go and look further, because you're going to be making care and placement orders. They're so significant, and we need to make sure we've covered all bases. And that's where the court says your genogram comes in really well, decent genogram, looking at that, seeing what's out there. And as I say, in this particular case, it comes with quite a £16,000 cost for not doing so, and some quite heavy criticism. So I'm going to move on. Sorry, Lisa, I think we started a bit late. I'm taking up Lisa's slot.
Hi everybody, I'm Lisa from Fenners. Picking up from where Penny left off, I'm dealing with adoption cases. There has actually been quite a busy year in the last 12 months for those cases. I think my clicker works now. Yay, it does. Perfect. You will all no doubt remember from November 2024, the Public Law Working Group report on post-adoption contact, and indeed the Court of Appeal in Re R&C. It's been a busy 12 months since then in terms of case law, and a really good one, if you have this issue in any of your cases, is Re L. It's very similar on its facts to Re R&C. The court at first instance made a care order and dismissed the application for the placement order. The local authority appealed, supported by the guardian. The child, and it's important to note the age, was 14 months. It was a case where there was a tension between an adoptive placement meeting the child's needs and the care plans for direct contact post-adoption. It's important to note that those were the care plans of the local authority in seeking a placement order for direct time with parents once per year and a minimum of 4 times per year with the big brothers. And this little girl had 2 older brothers who were 7 and 13. The recorder, however, refused the placement order and said he was unable to be satisfied that her important relationships with her parents and siblings would be retained if the placement order was made. So very similar to Re R&C. The Court of Appeal, in a lead judgment from Lord Justice Peter Jackson, said no. It was said that a standout feature of the welfare checklist was the child's particular needs. And because A was an infant at a critical stage of attachment, on any view, the greatest of her particular needs was permanence in both legal and relational terms. In other words, a home and a family to grow up in. That need was identified by all the professional witnesses, and there was no reason to undervalue it. The judgment contained only brief reference to a forever family, but described it as a benefit rather than a need. So that's a good point for your case summaries or position statements when looking at adoptive placements. The Court of Appeal went on to make the placement order and also made an order for sibling contact 4 times per year. What they said, which again is a good bit for your drafting at court, was that difficulties led to a false dichotomy between the importance of family bonds and the benefit of adoption, with one being found to outweigh the other. But the court here was not being confined to an either-or choice. Instead, the professionals advocated both and rather than either-or, whereby A had the benefits of adoption and a relationship with her family. There was also criticism, as an aside, that in making a care order only, with no placement order, there was no corresponding care plan, and the court was therefore unable to consider the permanence provisions for A, as is, of course, the requirement. So a reminder there that what the court should have done, having refused the placement order, was ask the local authority or invite the local authority to reconsider its care plan. Re-BA was in March of this year. This is about contact orders under Section 26 and whether you should have a recital, which, as you know, is non-binding, or whether there should be a Section 26 order. In this case, the court made the order, the local authority appealed, arguing in favour of a recital. The judgment went through to identify the key facts of why there should be an order. The court felt that the arrangement was fragile without one because the father had intellectual limitations, and the importance of the children keeping their contact with their father was very high in this case, where he was unlikely to be disruptive or undermining. There was also reference to the local authority's commitment to post-adoption contact being late emerging rather than being led by them from the start. Essentially, the appeal was dismissed and the Court of Appeal recognised that 2 judicial minds might reach different decisions without either being appealable. And here there was no flaw in the judge's analysis when applying the no order principle. There was also discussion of the Section 27 provision described by the Court of Appeal as a safety net. That is to say, if a Section 26 order is made, but it proves to be too significant an impediment to a placement, there can be an application to vary or revoke it, and suggested that the trial court could reserve any such applications to it. I haven't ever seen a Section 27 application to revoke, but there we go. RES, I'm going to skip through because it's long and also because it was from July last year, so only narrowly missed out on the training day last year. It was Sir Andrew McFarlane. It was the focus on sibling contact post-adoption, and he takes you through, in his judgment, the law regarding contact under Section 26. It's a good read if you have issues about sibling contact, and follows on very strongly from Re R and C. So if you're doing Section 26, you've got Re-R and C, followed by Re-S, followed by my first slide of Re-L. This one I put in, it's a first instance decision. It's one of those kind of warning type cases where things go wrong. As you know, Section 26 covers the earlier period in time for contact before any adoptive order is made. And then there is Section 51, capital A, for adoption, post-adoption contact. Here, I'll briefly scoot through the facts so you can see what went wrong. In March 2024, a care order and placement order was made for these children with a Section 26 order. There were 4 siblings in 2 separate placements, so they were 2 and 2, and the Section 26 order was for no less than twice a year contact between these 4 siblings. So that was March 24. 2 of them were placed in October 24, and 2 of them were placed in November 24 in their respective adoptive placements. But despite the Section 26 order, no contact between them between August 24 and October 25, such that when the applications were made by the adopters for their adoption orders, the parents sought a Section 51A order, not for themselves, but for the sibling contact. The court made that order, looked at the no order principle, noted that both sets of adopters agreed to twice a year contact. There wasn't an issue with the principle of it. But she said, whilst the adoptive families are well motivated, they live in different parts of the country and are strangers to each other. And she was not confident that support would be forthcoming from the local authority without a Section 26 order, given what had gone wrong before. It's actually a little sad, I thought, when I read it, because the adopters had written to the court and they said, we feel we have made every effort to do the right thing at every step of this process. It has been made more stressful and frustrating by the local authority. It is disheartening that we may be made subject to a court order due to their actions and not our own. But ultimately, for the court, it's the welfare of the children, and so those contact orders were made. This case is really useful if you're dealing with disclosure of the Annex A in a leave to oppose adoption application. It's a first instance decision for Mrs. Justice Harris in BM. The mother in this case was seeking leave to oppose under Section 47. 5, I think it is. She had been given a redacted copy of the Annex A, which only included the information about the child and the birth family, rather than the information about the adopters. As you all know from Rule 14, the Annex A is confidential to the court, and the court can direct disclosure of it or redactions. Despite having the redacted copy, the mothers sought the full copy, which of course has all of the confidential information in it. So if faced with that application, have a look at this case. It runs you through Rule 14. It runs you through the context of a leave to oppose application, noting that the statute under Section 47 limits the participation of parents. They have to obtain leave. And so when looking at disclosure, bear in mind you are at the leave stage. So what the court said was, we cannot say disclosure of the full Annex A will never be granted at the stage of a birth parent's application for leave to oppose, but in the court's judgment, it's highly unusual. This case is long, X and Y. It's the Supreme Court. It's dense. It's not light reading, so I don't recommend it. So take it from me that those 2 bullet points are what you need to know, which is that the High Court, under its inherent jurisdiction, has no power to set aside or revoke a validly made adoption order. They can be appealed if there's an appealable error. And then you don't have to read it because it's not an enjoyable read. It's very dense with lots of law in it. Skipping through that one then. This is a good read if you have spare time. I enjoy Riem. It is an unusual case, the sort where you read it and think, wow, and also why didn't it end up on my desk, because it is just unusual. In this case, and I will go through the facts briefly because I hope that they might raise your eyebrows. We had, in this case, a care order and placement order made in October 2024. The child was placed with prospective adopters, mum and dad, in May 25, and then in July they applied for an adoption order. So far, so good. In August, the Annex A was completed. The couple have a strong and stable relationship, it said. The birth parents didn't take part generally in proceedings, and in November 2025, Her Honour Judge Hudson made the adoption order. So that's November. They then had a celebration hearing to meet the judge with the child in January 2026, so a couple of months after that. The child attended with the adoptive parents, the adoptive paternal grandparents, and the former social worker. No doubt it was a lovely day. And about 2 weeks after that, it came to light to the social worker that the adopters had separated, didn't think to tell anybody, and that actually the adoptive mother was in a relationship with a male prisoner at the prison where she worked. And they didn't tell anybody. The chronology seems to be that the Annex A was August, in their defence. The adoptive father didn't move out of the home until October, but that was obviously after the Annex A, but before the adoption order was made in November. The prisoner sounds lovely. He was in custody for drug-related offences, battery, weapons, and also had once been accused of sexual offending, but it was NFA'd. So there we go. Also, the child had been to visit him in prison twice. Nobody thought to mention that. And this came to light. Proceedings were issued for an interim care order. So a good read, this one, if you've got some time one evening. But essentially, back to the law, the Court of Appeal said that prospective adopters, in case they didn't know, have a clear duty to the court to make full and frank disclosure of their circumstances at every stage of the process, up to making an adoption order, and that the court can be misled by words, deeds, or silence. The misinformation about the state of the relationship fundamentally undermined the court's decision. Yes. And they said that both parts of the appeal test was met. The order was wrong, and it was also unjust because of a serious procedural error. If the true facts had been known, that was the wrong order. T is an interesting case from this year in February, with competing arguments for care plans for this child. She was 3, and she had always lived with her foster carers from 5 days old. They sought to adopt her, and they sought an injunction to prevent the local authority, London Borough of Ealing, who had care and placement orders, an injunction to stop them removing T from their care. They wished to place T with her half-sister, who was already placed with adopters in North England. The Guardian supported the foster carers. So it's that tension between sibling bonds on the one hand, and referred to statutory guidance on adoption for local authorities about siblings being with the same prospective adopters, unless there's a good reason why not. That tension versus the fact that little T had only ever known that home with those carers and their 4 older children. So the court made a finding, Mr. Justice McKendrick, that the siblings had a close relationship, that of course sibling relationships are important and lifelong, but her welfare imperative was to continue to live in that home with her foster carers. It's the only home she has ever known, and to remove her is contrary to her welfare. He said it would be trauma akin to bereavement. I didn't read the judgment as being critical of London Borough of Ealing. The court said they understood that case and placed considerable weight upon siblings being together, and that is a crucial part of their identity. So he made the adoption order in favour of the foster carers. He made a Section 51A post-adoption contact order for the adopters of the sibling, subject to their consent, to have contact between the siblings at 6 visits per year. This one I'll just skip through. Slightly random, I thought, in the last year that there was 2 reported cases regarding the local authority disclosing findings, judgments, paperwork from care proceedings to the DBS. Again, don't read them. They're not particularly exciting evening reading on a Friday, but take it from me, those of you that work at the local authority, yes, you can. And you don't need a court order for that. And that concludes my presentation. Just going to hand back to Sally.
Across youth and family justice. I was going to try to pole vault up there and I decided against it.
So the tech is now going to be seamless for the rest of the day. Is that all right at the back? Super. Thank you so much for having me. And I think Leslie's left the room now, our previous speaker. But I just felt like that was such a powerful call to action for us all. And in many ways, she foreshadows some of the things that were on my mind for this contribution. So even in her absence, I want to say thank you. Let me just check if that works. It does work. Hurrah. I'm Amy Ludlow, and my route to this room is a little bit unusual. I'm here because I met Poppy's daughter. I haven't actually met Poppy yet. And I met her in the context of delivering some training for newbie prison officers in Leeds. Why on earth was I delivering training for newbie prison officers? Well, because partly it's relevant to my role at Shift, and I'll say a little bit more about Shift in a moment, but also my background before coming into this role was as an academic, a lawyer and a criminologist at the University of Cambridge, where I spent most of my research life being very interested in prisons. And so for both of those reasons, I found myself meeting Poppy's daughter and having a really interesting conversation about the relationship between youth justice and family justice. I've left Cambridge a few years ago and since moved to Oxford, so it's really lovely to be back in the region. I want to say a little bit then about what Shift is, what we do and why, and then offer some thoughts about why I think it might be at all relevant to you in the room today, appreciating that there's a diverse audience here which includes social workers, legal practitioners and others, and really to talk out loud about some of the dilemmas, the opportunities, ideas that are on my mind to think differently about the relationship between youth justice and family justice. And they really are very emergent thoughts, so I hope it will be the start of a conversation for those who are interested. So Shift then is a systems change organisation. We are a charity, but we partner with public services who are interested to do different things in relation to children who keep us awake at night, specifically children who pop up in terms of vulnerability in relation to crime. So we work with the children who are caught in cycles of crime or at risk of being caught in those cycles of crime. Why do we do that? Because we know in this room that too many children are still not living the lives in which they have safe places to call home and safe people around them. And some of our most vulnerable children are growing up with professional responses that are typified by short-term piecemeal interventions, by a frequently changing cast of professionals, and really important systemic gaps for their support. The consequences of that are devastating for them. They are obviously also devastating for the communities around them in terms of public safety. The children I'm talking about are disproportionately from the global majority. They are black, brown, mixed heritage children and Gypsy, Roma, traveller community children. And we're absolutely, therefore, committed to anti-racism and anti-oppression as part of that commitment to systems change. Our vision then for children, so you can see a sort of crude illustration of how life is experienced by lots of the children that we work with at present, which looks like a very crowded professional network around these children that we're most worried about, who deliver piecemeal interventions. You've got a substance worker, you've got a youth justice worker, you've got a parenting worker, you've got your social worker, and they come in and out of children's lives with the best intentions, but often feels very overwhelming and often creates a sense of inertia around these children that we're very, very worried about. And the pattern that we get stuck in is multiple assessments for these children. We assess repeatedly but never intervene. We never have the opportunity to really build a holistic relationship with that child and understand what's going on for them. The vision that we want to advocate for is depicted in the top right. So where you've got a young person with a much smaller and more focused professional network around them, people who stick with that child, who know that child, who hold significant aspiration for that child and walk with them in a flexible way. The children that we work with tell us to, excuse my language, fuck off for 3 to 6 months. And we as professionals expect that to be the case and see it as our responsibility to build a relationship, not just with them, but with their communities and with their families. That means showing up for them in the spaces that matter most, whether that's in police custody, whether that's when they're being excluded from school, when they're experiencing harm in the community, whatever it takes to build a trusted relationship with that young person. And from a more systemic perspective, we're advocating for changes in policy and practice to reflect that, so that the obsessive focus of our work with children is about relationships. The Children's Minister has recently sort of stated that as a central organising principle of the care system, namely supportive, enduring relationships. We would really echo that. We're particularly anxious about the man-made trenches that currently exist in the system for the most vulnerable children. When they turn 18, for example, that man-made trench there. When they move out of area, often into high-cost, deeply unsuitable and deeply ineffective placements. And when they go into and out of custody, these are currently experienced as absolute gaps in provision, and the most vulnerable children fall into those man-made trenches, and that needs to change. So practically, what are we doing? We're partnering with public services who want to do something about this, and we're getting our sleeves rolled up. I've never been interested in leading organisations that just do advocacy work from the sides. I've always been interested in getting stuck into the complexity of making change happen, which means that we practically create multidisciplinary teams, typically to date within local authorities, who work with the children who, quotes, keep professionals awake at night. Those children are identified through multi-agency assessment and nomination that's designed in a way to get at the children who might otherwise not be seen. I'm thinking there about girls. I'm thinking there about Asian children, for example. I'm thinking there about children from traveller communities. So anyone who wouldn't comfortably fit into a box because they don't meet a statutory threshold, because their harm is hiding in plain sight, as the Children's Commissioner described it, because none of the agencies are putting the pieces of the puzzle together to see the pattern of harm and vulnerability that's going on, not just for those children, but often intergenerationally. We see patterns of intergenerational harm, poverty and abuse. And from that practice work, we're demonstrating a different way of being and doing, and understanding what's difficult about that and what the kind of key contexts and enablers are. So we're doing lots of learning in iteration with our practice, and through that, we are growing a kind of movement for systems change. So all of our influencing work comes from our practice. Is this all making sense, other than me clicking the wrong buttons? Yeah. In terms of people, so one of our founders was Josh McAllister, current Children's Commissioner, current Children's Minister, and we've got other fantastic people on our board who have all been intimately involved in social innovation in the space of vulnerable children. Breaking Cycles is our practice model. Some of you in the room might have heard of the organisation Pause. Pause is our sister charity. Pause works with women who've had repeated removals of children into care. Pause draws attention to the systemic gap for those women where often we were taking children into care and not ever stopping and doing the work with the woman to think, how do we stop this? How do we stop these cycles? So Pause is speaking into that gap and trying to do something in relation to it. Pause uses the same practice model as us, which is Breaking Cycles. We've got a common co-founder of Pause, which is Sophie Humphreys, and she created this model. It's at the heart of it is high quality relational practice. I think of it as good old fashioned probation practice. I think it's the practice that many social workers came into the business to do. So at the heart of it is that skilled, empowered practitioner who is enabled to work flexibly in a way that's totally tailored around that child, and to work with everybody who matters in their world, and to persist. So we work with children at shift for at least 18 months because we know that that's what they need to make any meaningful change. And these things are really easy to state in terms of what we want to get from and to, but they're really difficult to do in practice. So at the moment, we might describe responses to these children as typified by being about what is easiest for process rather than what is best for the child. We might describe them as focusing quite narrowly on immediate safety and attending much less to that more aspirational vision of improvement across all aspects of life. Short-term intervention, multiple handoffs to a repeated changing cast of professionals, rather than holding and pulling for help through a multidisciplinary lens and sticking with that child as a consistent relationship. Seeing children as individual problems to be fixed. So seeing children through individual lenses, you are neat. You are a care leaver, you are a victim of modern slavery, you are a perpetrator. Actually, we're saying we need to focus much more on the relational patterns that exist around that child that are resulting in harm. So we're not locating the opportunity and the responsibility to change inside an individual child. We're saying we need to disrupt and change the context and relationships around that child to build long-term safety. And then also a pattern from working in fragmented hierarchies with our sort of obsession with social work and the social work qualification, rather than a more plural thinking through about other qualifications, other forms of professional experience that can really add value to safety building, to a position where we're staying in the complexity with that truly integrated network of professional support where all agencies are valued for their safeguarding abilities. And in practice, then, where are we doing this work? So our national office is at Quorum, which is in London, but we've got sort of key hubs are in Manchester, Greater Manchester, up in the northeast, in the Middlesbrough area, and then we've got some stuff in Greater London and Essex. Our aim isn't to scale the work to meet need. Our aim is for systems change. So what we want to do is partner with the right sorts of public services that can test and demonstrate a different way of operating from which then government can be influenced. And by government, I mean local government, regional government, and of course, national government. So why on earth do I think any of this might be interesting and important to you? So a kind of common pattern of our work is children coming into care late, sort of 15, 16. Those children, or the children that we work with, typically have risks inside and outside the family home. It often means that they get placed into semi-independent accommodation, and in that context, risks to them of exploitation and other harms often increase, and there's significant concern for their well-being. We often work with children who are on deprivation of liberty orders, and many of the children that we work with, probably most, are open to youth justice. So they might be on a current order, or they might have had previous youth justice orders. And I tell you that because I think one of the things that really resonates for me from what Leslie was saying is that there's a real challenge for us about parallel proceedings, or not even parallel proceedings, consecutive proceedings that often take years. So it's very common for our children to have experienced care proceedings, and then a deprivation of liberty order using the inherent jurisdiction, and then many months, sometimes years down the line, go through criminal proceedings because of the Crown Court backlogs. And this is bewildering, confusing, and our experience of those different jurisdictions is they operate almost entirely without any connection. So my child is described in care proceedings as a child who's vulnerable and in need of protection from a terrible parent, typically. My child is simultaneously described in youth justice proceedings as a culpable offender, adultified typically, because I'm often working with black or brown children, adultified and described as a violent mini adult who is entirely culpable and responsible for their own behaviours. I think the common feature across all of these all of these different types of proceedings that often we're vilifying the parents. Again, I'm not saying that this is intentional, but often the experience for the children and families we work with is that their family members feel vilified. Perhaps that's unsurprising, that tension. I'm thinking about the structure of national government, and I'm often drawing attention to the fact that our children sit really uncomfortably across the Department for Education, the Home Office and the Ministry of Justice, and there isn't really any integrator of the most vulnerable children. Think about family justice and court proceedings, where you've got both the DFE in the game around child protection from a child protection perspective, and you've got the MOJ from the sort of private matters. I think the other thing for me is sort of looking to youth justice. Many of you will have heard about the Child First evidence framework. And I think we've seen some really positive benefits about how that evidence base is being used and mobilised in practice. There's been a quiet revolution in the youth justice system, which means that we used to have around 4,000 children in custody in child prisons, principally youth offending institutions. We've now got around 400. So we've gone from 4,000 to 400. And the public, I think, are largely unaware of this, but the Child First evidence base has played a really important role. There's now conversation around what does Child First policing look like? What does Child First prosecution look like? Why do I think that's relevant? Because two things. While that progress is really positive, there are still big issues in the youth justice system. So one of our particular focuses at the moment is on remand. About half of the current population of children in custody are there on remand rather than sentence. So that's about 200 children. And of those 200 children, about 60% will walk away without any disposal. So they won't be convicted of an offence for which they receive a community or custodial outcome. So we're exposing quite a lot of the most vulnerable children, who we know are disproportionately care experienced and global majority children, to the harms of imprisonment without good cause. I think the other thing to note is that we're seeing an explosion in the 18 to 25 space of young people in huge distress. So diverting children away from the youth justice system, but into other systems that are not able to meet their need. And how that manifests in the adult prison estate is young people, 18 to 25-year-olds, very significant distress, sometimes on short sentences, coming out and causing significant harm in the community, being breached and recalled. So we've got this really very worrying cycle that's happening for 18 to 25-year-olds. I'm very worried about the unintended consequences of diverting children away from the youth justice system into a child protection system that I think is not suited to the needs of adolescents who have risks inside and outside the home. And also the grappling with the realities of teenager autonomy. Fundamentally, I think our child protection system is still built around the paradigm of infant and parent, not adolescent in the world exposed to all of the harms in that community. And our position is that the children's social care reforms, the Families First reforms, don't really address this group at all. And one of the contexts to this that should be on all of our minds is the Southport inquiry. And we are deeply worried about what's coming out of the Home Office in terms of violence-fixated individuals. I don't think there's enough rallying across all of us as practitioners who care about this most vulnerable group of children in relation to that. And obviously, all of this has a broader context. So all of this has a massive broader context around levels of need for young people, around the crisis in residential accommodation, the crisis in CAMS provision and mental health support, and the shocking rates of national child poverty. So I guess my wonderings to throw out to you, and really this is an invitation for further conversation, are threefold. And these have been influenced by some of the work we do with the Nuffield Family Justice Observatory and their work, which is devising a new strategy for family justice. So the first wondering is about the role of family courts and legal practitioners as system integrators and problem solvers. I think the work of the family drug and alcohol courts is really promising. It points to a different model and relationship between people who use courts that I think we need to reflect on. But some of the dilemmas on my mind in relation to this is, in some ways, the culture of practice at the moment in relation to child protection is that if the matter gets to court, it's in some ways a failure. Right? Our efforts are to try and keep everybody out of court, and we want to largely keep judges out of the business of social work assessment, I think. So I think there's something about that narrative that might be a challenge to thinking about courts playing a more active role of integrating the quality of care and the experience of care for the most vulnerable people. I think another sort of dilemma is around the kind of growing commitment to transparency, voice and participation, but how that sits sometimes in difficult tension with concerns around the dignity of the court and the bench, and sort of formality, process, impartiality. And I think we're in a really unresolved place in relation to that. One of the peculiarities that I have experienced since stepping into this role is, having previously worked lots with lawyers and judges, I've written to several judges from my new position, and those judges are often unwilling to speak to me because they say I'm seeking to influence their decisions and I'm too policy facing. I think that's not a helpful position. I don't think it's a justified position. And I think it's absolutely imperative that courts and legal practitioners are involved in helping us all understand and design better responses for the most vulnerable children. So I'm really worried about that. Secondly, I think I'm wondering about our theory of change for family justice. So I'm thinking about how helpful the child first evidence base has been in the youth justice space, and I'm wondering what's the equivalent in the family justice space, right? So what is it, what are our ideas, and what's our evidence base about what actually keeps children safe, and how could we come together around that evidence more explicitly and use it as a tool to shape our practice in a more consistent way? And I think, thirdly, I'm wondering about how our frameworks and practice need to change to meet the challenges of adolescence. So within that, I think there's a case for being much bolder in the family justice space about race and about inequity and conversations about those things. I think there's a very strong narrative in the youth justice space around the experiences of global majority children, and I would like we would like at Shift to be part of a conversation that encourages that to extend into the family justice space. I'm struggling to find people who are championing those issues, and I think that's sad, and we want to be part of changing that. And I think probably I'll stop there. That's enough food for thought. Thank you for having me.
Great, thanks everybody. We've got a really busy afternoon sessions looking at private law, a talk from Kafkas, and then financial remedies. To begin this afternoon, we have the first speech from Her Honour Judge Gordon Saker, our designated family judge. Thank you.
So is this working all right? Yeah, good. Frankly, I'm amazed you're all here because the tennis has started. And I stand before you as somebody who spent part of her daughter's wedding reception watching the US Open final. So, you know, the fact that you're here I find quite remarkable. What I've done a very short PowerPoint, not so much to tell you about now, but so that the references are there when you get the pack later on to a few links. Unfortunately, when I was checking it through this morning, I realised somewhere I jumped half a sentence to another sentence, so I'll try and get that corrected afterwards. First of all, I really want to say, on behalf of all of us, a lot of thank yous, because we come to this day every year, and it's a superb day, and all the people who put it together and who give the talks do so much work. First of all, Elaine, who organises the venue for us and chairs the local Family Justice Board, she's lost her voice, so it's very good. So thank you to you and Peterborough City Council for offering us the venue and organising it. It's really good. The speakers have been excellent. I have to say that I think Dr. Mohammed may have gone, but he gave evidence in a case before me not long ago, and he was very thoughtful and considered all the options and gave his evidence very clearly and very helpfully. So I certainly say he is a very, very good expert. The other speakers have all been very interesting as well so far, and there's more to come. And of course we get the speakers because the organisers, Lisa, Sally, Penny, put all the work into getting all of them for us. So I want to thank them as well for all of that. And then lastly, frankly, I want to thank all of you, not just for coming today, but for everything, because we're all in this family justice system. I don't think any of us are in this to get rich. Or if we are, we've chosen the wrong profession, I think. But everybody works so hard. We all have our moans. I say this particularly, I know there are some local authority people here who I've moaned at occasionally. But on the whole, we all work really hard, and the system would not work without all of you being in it. So as well as thanking our speakers for today, I do want to thank all of you for the hard work you put in, day out for family justice, because I think it is extremely good, and everybody works very hard. If I could pick up on one thing from this morning, and that's the talk about family group conferences, and here I'm speaking probably mainly to local authorities, because it was clear from that talk that if you get the family together early on, you really can make progress. So I would say one thing which I often find lacking is get a good genogram, because if you don't know who's in the family, you're going to struggle to get a family group conference together. But get them together earlier. There's even a sentence in the case management order about filing the minutes or arranging it. And that really is important. And I thought that was a very good talk. So I do want to urge all of that upon you. I can give you some good news. I don't often come here with some good news. The first is that we are having new air conditioning in Cambridge County Court that should actually work. Who's been there recently? A few of you? Wasn't it better? Yeah, well, that's good. We've also got some new judges this year. I'm sure some of you have met them already. We've gained Heidi Berry and Marie Southgate, who, of course, I know lots of you know already. And then we're getting another new judge in Cambridge in September, Simon Harrington. So that's an improvement for us. We've got some more judges. Sadly, we're losing Jason Slaney because he's moving to Norfolk. So we've lost one, but we've gained three. So that's a positive, which I can tell you about. And then what I want to do is really just draw your attention to a few things on here. Some of these, I'm sure you know, that there is a new practice direction came out a few months ago, tidying up the practice directions in relation to bundles. I just wanted to highlight a few things. The case summary is meant to be 6 pages. Position statements should be concise and not exceed 3 pages. I just thought I would highlight those for you all. But there is also a lot of information in that practice direction about what should be in bundles. The other thing I've put on this slide, which you will get more of when you get the presentations later, is there's new combined allocation guidance, which now includes all tiers of judiciary, including magistrates. It used to be sort of levels of judge and then not very clear what went to magistrates. So there's now a comprehensive set of guidance, which is quite useful, and that came into force in May. Who here has heard me moan about special guardianship support plans? Oh, yes, there we are. Well, there's a very good article in the recent edition of Family Law by Louise Ballantyne. I think Louise was here somewhere. She's hiding now. disappeared. Oh, she's down the back. There we are. It's a very good article by her. And the important thing about support plans is they should actually talk about the support as opposed to just here's a list of websites. So do read that. And another reference I put on here is a High Sheriff's Instagram post. Many of you probably know that the High Sheriff is a largely ceremonial role, but some of them take it more seriously than others. And the last couple of years, we've been fortunate that they want to come see what goes on in court. They also want to support the voluntary sector. And the High Sheriff came and sat in with me a few weeks ago, and he put a very lovely post on his Instagram page about the quality of the work done by the lawyers, by the social work team, and also about the court staff. So if you get a chance to look at his Instagram page, I've put a link there. Another matter I've put on the slide is a programme called Illuminated. I don't know if any of you have heard this. It's on a Sunday evening on Radio 4. And last Sunday, it's half hour, it was all about later life letters. And it was very interesting the impact these had on the recipients. So if you get a chance to catch up on that, on the iPlayer, do have a listen. Because, of course, social workers, guardians, judges write letters to children. But it was very interesting to see that the impact they have had on real people. So I've mentioned that there as well. This is the one where the middle of the third bullet point jumped to the wrong place. So I'm sorry about that. One of these things I've been asked to point out to everybody, although I suspect a lot of you know this, is that the public law portal, and indeed the money portal as well, work in real time. So if you've got something that you've got confidential information, or you want a recovery order, but you don't want somebody to know about it, do not upload it to the portal, because it will go straight to them. You email the FPL email address, which I'm sure you've all got. So that was a useful thing I thought to pass on. And then I put a slide there about titling things when you orders, because it helps their system, apparently, if when we upload documents, you put case management order 1, 2, 3, and then at the last order, you actually head it final order. And I've just been asked to mention that by the portal team. The bit that I then said was about naming documents, and you'll see that's gone a bit wrong. But that's another thing. Instead of putting on your uploading that comes in case file view, position statement of so-and-so and so-and-so, if you just put PS or something, or CS for case summary, it's much easier for people to find it. So those are relatively minor points. One thing I did want to mention is the case of Re-S. Not so much for its decision, but in it, the current president gives some guidance about litigants in person and the fact that they don't have access to the portal. And a suggestion is that you nominate one party, probably the local authority, to ensure that all the interveners' documents are uploaded and go backwards and forwards on the system. So that was quite a useful piece of information where you've got interveners in person. Those were the main things I just wanted to say to you all to bring everybody up to date. And then these are forthcoming attractions, for want of a better word. The private law portal, which everybody tells me is an absolute car crash, is going to come soon, and we're all going to be stuck having to use it, so be prepared. Child-focused courts, I don't like the name, but I like the idea, are going to be coming our way soon, and they will improve the system. We're fortunate in this area in that CAFCAS don't have huge delays, but this will improve the system. But one of the things, this is for the private law practitioners amongst you, one of the things we have to do before these things come in is close old files. And we're going through them and discovering some that have never been finalised. And what is happening is we are having to list them for hearings, probably later in the year. If you suddenly get an order listing a hearing and you're thinking, but we finished this, then send in a consent order explaining that with some recitals, and then we will close the file and we will vacate the hearing. But that's just warning you that that's coming down the line. So those are all the things I wanted to say. I think that's the end. Yes, there we are. But I just want to tell you one other, a very short story, if I may. We often get told that our orders need to be very precise, particularly for non-molestation orders, for example, because you're dealing with somebody's liberty. And one of our deputy district judges came in to see me the other week and said to me, "Can I ask you about an order you've made?" So I said, "Yes, of course," thinking, here we go, what have I done wrong? And he said, "I've got an application for a non-molestation order in my list this afternoon. In your last order, you've provided for the father to have letterbox contact only." "Yes," I said. "He's been round to the house shouting through the letterbox." So I just want to warn you all, think about what you put in an order, because I think technically he may not have been in breach. Anyway, there we are. Thank you all very much.
Thank you, Judge. The next speakers are Rebecca Clark and Eva Filipovic, both barristers at Regency Chambers, and they will be delivering a speech on the private law updates. Let's just sort the slides out. Oh, the clicker, yes. So first up is Rebecca Clark.
Afternoon, everyone. We've put a lot of detail on our slides, so the plan is that we're going to talk through them, but please look at the slides afterwards for the further detail. And we've included links to Bailey as well, so that you can see the case for yourself as well. The first case that I'm going to talk about is Re-J, M and P from March this year in the Court of Appeal. This case is about parental responsibility and what are the legal consequences when an individual is not in law a child's father, but has been registered as such on the child's birth certificate. And it's an issue that has been raised before and addressed in other judgments, but as I say, this is something that's reared its head again. So the issues for the court were firstly, what is the definition of a father? And by the time of the Court of Appeal hearing, that had been resolved by consent, that it's the biological father is the father. And then the question was, if an individual has been registered as the child's father, do they get parental responsibility even though they're not the biological father? And when it's discovered that they are not the biological father, does the parental responsibility automatically terminate, or does an order need to be made? And what's the test for terminating that parental responsibility? So just going through the facts of the three cases, in Re-J, the mother and father, believed at the time, they were an unmarried couple, and AJ, the father, was registered as such. He believed he was the father, and then it wasn't until 2 years later, when the couple break up, that mum reveals that he's not the father. DNA testing confirms this, and at the time of the hearing, Jay's biological father, he's not involved in his life, but it's come to court because AJ's made this application for parental responsibility. And then mum has made an application to say he's not the father. So the issue was what parental responsibility had AJ had, and what should he have for the future? And AJ is saying, well, I'm registered as the father, so under Section 4 of the Children Act, that's given me parental responsibility. That should be enough. I've now got that. But at first instance, the court says pretty much what you may expect, that no, the father has to be the biological father. Because he wasn't the father, then he should have never been on that birth registry entry, and then that means he never obtained PR. So because he never obtained it, you don't need an order to remove the PR. Then in the next case, the next set of facts, Riem, in that one, the mother and the father had purchased sperm over the internet from an anonymous donor, and AM was named as the father on M's birth registry. And AM claimed he didn't realise that that was an issue. He thought, it doesn't matter, I can still be named as the father. That case comes to court initially through care proceedings, and the local authority have concerns about the purported father and don't want him to have parental responsibility. So the local authority are seeking an order to say, if he had any parental responsibility, we want that terminated. Again, at first instance, the judge reaches the same decision by a slightly different way of saying, well, he's not the father, and any PR that he did have, well, he never had it, but just in case, I'll terminate PR. I'd have made that order anyway, the judge said. And then the third part of this conjoined appeal is a really, I thought, really interesting one. It's about identical twins. And in the case, they call them TP1 and TP2. So TP1 is named as the father on the birth entry. And TP1 is definitely the father of P, that's P's younger sibling. That's a fact. But then TP2, as I say, is the identical twin of TP1. And at first instance, the judge says, P's father is either TP1 or his identical twin brother, TP2. It's not been possible to establish P's paternity either by DNA testing or by an examination of the circumstances of her conception. They had a fact-finding hearing, and they found that both brothers had had sex with the mother within 4 days of each other in the month when P was conceived. And so it's equally likely that each of the brothers could be P's father. But as I say, it's TP1 that's on the birth certificate. Now, by the time of the final hearing, Mum and TP2 are now very close. So Mum and TP2 now want a declaration that TP2's the father, and she wants the parental responsibility to be conferred onto TP2. TP1, however, wants it to remain that he's the father. There's a 16.4 guardian, and they want it to be that there's a declaration that neither twin was established to be P's father, and that actually we should give PR to TP2 by way of a child arrangements order instead. So at first instance, the judge decided to didn't want to make any declaration as sought by TP2 or the guardian, so wanted to keep it that it's TP1. And that was because the judge deemed that given the probability of either brother could be P's father was 50-50, then no one's able to discharge the burden that it is either TP1 or TP2. And the judge doubted that there was jurisdiction that she could even make the order suggested by the guardian. And the judge acknowledged that, well, if I keep TP1 on the birth certificate, then on one hand that might be wrong and an untruth for P, but on the other hand, it could be true, and the registration's not necessarily wrong. And the judge, in what must have been a really tricky case, decides that she won't attribute PR to TP1 or TP2, and she'll just leave decisions to the mother. But the Court of Appeal go on to say that that didn't really grapple with everything. So TP2 is then appealing this decision because he seeks a declaration that he is P's father and that TP1 is not the father. And he challenged the decision that the judge did nothing to remove TP1 from the birth certificate. So in terms of the arguments on appeal, in the case of AJ, the first set of facts, as I said before, he's saying that, well, it doesn't really matter if I'm not the father. We've got the legislation that says if you're on the birth certificate, you can have parental responsibility. And in M, there was a similar argument as well, and saying that, well, I'll remain as the father until it's proved differently. And they're saying that to require parental responsibility under Section 4, it's not a requirement that there has to be DNA testing. So it can't be right that it has to be the biological father. And in the case, there are interveners from the Secretary of State, the Association of Lawyers for Children, and Reunite. And the Court of Appeal likes the arguments from the Secretary of State. They say, which might not be a surprise, is that where an individual is registered as a child's father, then they only get that parental responsibility if they are the biological father. And although the parties may believe otherwise, there is no parental responsibility at any stage. What the court says, what may need to happen is there needs to be a child arrangements order and a parental responsibility order under Section 12 as well. And one of the other interesting points they discuss is, they call it the abduction gap in the judgment, of if a parent has taken a child out of the country and then the left behind parent, so if the father who believes he's the father but it isn't the biological father, then they're clearly at a disadvantage. And the court says what needs to happen is consider interim child arrangements order to prevent that issue. In P, which was TP1 and TP2, the identical brothers, the case is a little bit more complicated. The Court of Appeal say that the first instance judge was wrong to not grapple with the issues. And the court decide that TP1 remains on the birth certificate because as TP1 is not proven to be the father, he still could be the father. But they decide to revoke his parental responsibility because they say that does create an ambiguity. And that's not in P's best interest. And if I'm just going to skip through the slides. Whoops. The next case I've got is linked to TP1 and TP2. It's the welfare decision that then has to be resolved. And so if you're wondering what happened, what did the judge decide in terms of a child arrangements order, of how did that work for the family, what happened was the judge made a child arrangements order for the child to live with their mother, but also that the child will spend time with both TP1 and TP2. The reason I've included this case, though, is it's a reminder of how hard it is to appeal a welfare decision. So there was 2 grounds of appeal that I've picked out where they're saying that the court failed to adequately balance the risk posed by one of the fathers removing the children from the other father's care, and the impact at all of the child arrangements on how it would affect their understanding of their role in the family. And I've included a quote here that I've highlighted in bold the parts that I think are particularly pertinent, that on appeal, the court could only overturn the decision of a judge on a point such as this if it was clear that the judge's evaluation was wrong in the sense of not being reasonably open to the judge on the evidence. There is simply no basis for holding that is the case here. And over the slide, at the end of that on the screen, highlighting that it's thus a challenge as to the degree to which the judge sought to reintroduce TP1 into the child's life, rather than an assertion that the judge was wrong to do so at all. So again, emphasising that it's really hard to appeal a welfare decision, and essentially setting out that if the judge has looked at all of the evidence, as long as it's not wrong, then an appeal is really going to struggle. So I included that case just as a reminder. And then the following case that I have is also one on paternity. It's clearly been a topic that's in the Court of Appeal quite a bit this year. And you may have already heard of Robert Alban. There's other cases relating to him as well, which he's an unregulated sperm donor. He says that it's 180 children over 12 countries that he's been a donor to. And again, the issue in this case is when the court can refuse a declaration of parentage on the basis of public policy. So the facts of this case is the child was born in 2021, and I'm going to call it her social father because that's how it's referred to in some of the case law where one thinks they are the biological father, but they're not. Her social father began identifying as transgender and originally female, and mother and him wished to have a child. So he did the research and found Mr. Alban as a possible sperm donor. And the decision goes on to how Mr. Alban advertises on Instagram and Facebook. So he was going to provide the sperm for £100, and then he attended again for a £150 Amazon voucher. Mr. Alban's request, though, is that he's told when the child is born. And the mother in the case is very clear that that was going to be the end of the contact. He was not going to have a role in the child's life. So mother and social father then register the birth and register the social father as the father. And Mr. Alban applied for a declaration that he is N's father. And he also sought contact, but that wasn't pursued. And the Court of Appeal dealt with the judgment on this one after Re-J, Re-M and Re-P. And as I say, this Mr. Alban, he's a bit infamous. This isn't the first time the Court of Appeal have had to deal with him. He's previously been described as a man who has a complete absence of sensitivity or empathy, is wholly self-centered and will stop at nothing to get what he wants. And as you can imagine, a lot of the mothers are vulnerable people. So the courts clearly don't want him to be on the birth certificate. That you can tell from reading the judgment. But they have to look at how that can be avoided. So the court may refuse to hear an application for a declaration of parentage if it would not be in the best interest of the child. And that's, they have to consider that the determination of the application would not be in the best interest of the child. And that's a really high threshold, it's described in the judgment, to reach. It's a really high bar. And the court is only released from that obligation to make a declaration where to do so would be manifestly contrary to public policy. So as you can imagine, that's where you're hoping the judgment's going to go. And I'll leave some of the slides to read in your own time because they set out a series of principles. So there's principles on what the court looks at to decide that, to determine the application would not be in the best interests of the child. And then there's the principles that they look at on public policy. And again, it's a high bar, but they note the scale of which Mr. Alban has operated outside of the licence provisions. But what the court does conclude with is, on this slide here, that they're sending the message that just because the conception wasn't arranged through a licensed clinic, it doesn't mean that the court is always going to say when it's been an informal arrangement that the registration will be excluded on public policy grounds. So that's a reminder that it won't always be the case, but given Mr. Alban and the serious findings the court had made against him before, this was within that remit. And then the last case that I have is the case of M and F and A. This was a decision by His Honour Judge Owens in Oxford. The reason I've included it is it's a little bit different because the court makes a prohibited steps order until the child is 18. And the judge also makes a non-molestation order until the child finishes university. The reason for that being the judge notes that to make the non-molestation order for that long, he could have just let her apply when she's 18, but he notes that would cause her emotional and psychological harm. It's quite an interesting case to have a read of. Unfortunately for the child, there had been 14 case numbers that the judge could find on the system, and she was nearly 17, and the parents had been in litigation since she was about 18 months old. So quite a sad case for the child, and the court had given the father a suspended sentence a few years ago, and it hadn't worked. He just sought contact on his own terms. So just including, though, as a reminder that we've got that in our toolkits as well in those exceptional cases. So something a little bit more different. And I'll just pass on now to Eva.
Hello. Oh, that's loud. I do apologize if it's really loud. So yes, thank you. I will be continuing and outlining a few other recently published cases in private law. So the first one that I will be starting with, perfect. So it's a W and A and others. So this one was reported recently, so in December 2025. And this one looks at the issue of, firstly, when there's father's application for a spends time with order, whether that should be refused because of safeguarding concerns. And more notably, the judge made a section 9114 barring order without notice to the father. So just to provide a quick background on this one. So there are two subject children in this case. The father made an application to spend time with these children. He did have a criminal record. However, he claims that his lifestyle has changed completely. The safeguarding letter indicated that there should be no contact in the interim. There was also subsequently a Section 7 report, which actually did recommend indirect contact, despite the children being very adamant that they did not want to spend any time with this father because they have witnessed domestic abuse. The father didn't accept this. He accused the mother of alienating the children from him. And what's really notable here is the father's conduct throughout these proceedings. So he initially had solicitors who had to come off record because of his behavior towards them. He then became a litigant in person. He was appointed a QLR, and then the QLR was later discharged, again, due to the father's behavior against him. He was behaving very aggressively towards everybody throughout these proceedings. So in judgment, it was held that despite the children generally benefiting from having a relationship with both parents, of course, the application was dismissed because the children's welfare required it. The judge did comment that the father was consumed by his own emotional dysregulation, which created a safeguarding risk. And then further to that, the court also made a 9114 barring order. So just if anybody's unfamiliar, so this is basically providing an obstacle. So if the father wants to make any future applications, he would have to make an application to the court first for permission to then make further application. So this was made without notice to him. The reason the father was not warned about this ahead of time, that this order was going to be made, he did not attend the final hearing, so he wasn't actually there to understand why this order was made against him. And the court recognized that normally the affected party should understand the order being made against them. However, the judge noted the developed law and that 9114 orders can be used more widely now to protect children, and they're not only used where there's been excessive applications. And I know sometimes that might be not a misconception, but people still might widely believe that there has to be those repeated applications. But this recent case reestablishes that it is also to protect the children. And in this case, it was specifically because the court believed that the proceedings were used as a weapon of conflict between the parties, and it was because of father's extreme conduct that they did make this without notice against him. So again, just a reminder of when you can use these 9114 applications. The next case is IJ and KL. So this is a case where the mother wanted to relocate to Spain from England with the subject child. And this is a case, the reason I've included it is because sometimes in these relocation cases, they very much are case by case. And it's interesting to see which factors this case specifically looked at to consider whether this application should be granted or not. So in this case, we have the subject child who is 10 years old, lives in the UK with the father. Mother made an application for child arrangements for the child to live with her, and also a specific issue order for the child to relocate to Spain where the mother was living. The father opposed the application, and within their report, CAFCAS recommend that the child should remain living in the UK. So the court in their judgment, so they considered the welfare checklist. Obviously, the central issue was whether the arrangements would meet the child's welfare needs. And in this case, the court specifically looked at the cultural barriers that would happen if the child did relocate. So some of the things that the court looked at in this case specifically was the fact that the child spent their entire life in the UK. The child spoke English, not Spanish, and the court cited that this was a significant obstacle, especially given the child's age. They were 10 at the time. The child was due to start secondary school shortly. The wishes of the child were not clear, so the child simply just wanted to spend time with both parents, so that wasn't really taken into consideration. And one of the issues was also that the mother's relocation plan, it was uncertain. So it wasn't clear where the child would go to school, where they would live. Nothing was clear in her plan. She also had little support network in Spain, and the judge determined that, yes, the child would eventually adjust, but it would be over a significant period of time. Therefore, the child dismissed the application. The next case that I'm looking at is the case of Rie, a child habitual residence. So this is a case where it's a high court decision concerning the wrongful retention of a child in India. So just to give a background to this case. So the child was born in 2022 in the UK. Father is a British citizen. He renounced his Indian citizenship. Mother is an Indian citizen. However, she does have indefinite leave to remain in the UK. The child is a British citizen as well. The parents renounced the child's Indian citizenship. In 2024, the parents separated, and they both agreed that the mother can take the child at this age. The child would have been about 3.5, or 2.5. That the mother can take the child to India from December 2024 until September 2025, because the maternal family and paternal family are both back in India and spend a bit of time there. The father agreed to this because it was agreed again, she would come back September 2025. Whilst the child was in India with the mother, the father did have regular indirect contact. The father also went to visit the child in India as well. However, he noticed by June that there was a change in the mother and that she was more reluctant to allow indirect contact between the father and the child. In September 2025, the mother did not return to the UK with the child. 13th of October, the mother applied for permanent custody and guardianship in the courts in India. A few days later, the father made an application under the inherent jurisdiction to deal with the case. And if the court found that England and Wales did have jurisdiction, then summary return of the child and then any ancillary applications thereafter. So the question for the court, therefore, was the child habitually resident in England and Wales, or was it habitual residence in India? So the court had to carefully balance the factors in favor and against both habitual residence in each jurisdiction. So the court looked at in favor of habitual residence in England and Wales. It was the fact that the child had only known England prior to being removed. He was registered with the NHS here. He had an address in London. He moved to India, which was only agreed as a temporary stay. The father was having regular contact as well. And the child is a British citizen. His Indian citizenship was relinquished, and the child does speak English as his first language. Then the court had to also consider in favor of habitual residence in India, which in this case, it was the fact that the child's age was probably the most significant factor, because at this stage, the child had very little memory of his time in England. He developed a much deeper conscious understanding of his time in India, because again, he was only 2.5 when he left. At the time that this was before the court, he spent 16 months in India. His basic care needs were met in India. He was settled there, and he had a wide, both maternal and paternal family there. So, giving judgment, the court determined that firstly, the relevant date for the jurisdiction purposes was the date of the father's application. So this would have been the 17th of October when he made his application. Then the court determined that it did lack jurisdiction. It determined that the child's center of life and integration was in India, and held that the habitual residence shifted away from England. It said that even though the child had a previously deep and permanent link to England, the quality and stability of his residence in India outweighed that to England prior to the relevant date. The judgment emphasized that determining habitual residence is a strict question of fact, evaluated on a case-by-case basis as well. So because the court determined that the English court lacked jurisdiction, all of the relevant welfare and custody issues fell to the Indian courts. I do apologize, I'm not great with the PowerPoint slides, but they will be shared, and I've included all the relevant information on there, so you can always refer back to them if so required. And then the last case that I'm going to be talking about is a really interesting one. So it's called REY, Expert and Alienating Behavior, the Modern Approach. So this is a case where Sir Andrew McFarlane handed out judgment reshaping the family court's approach to both expert witnesses and allegations of alienating behavior. So to give a background to this case, so the background is really important. It is quite lengthy, so I do apologize. So there's 2 subject children in this one. In 2018, the father issued private children applications seeking for the children to move and to live with him. Both parents made allegations of serious domestic abuse, including there was allegations of both physical abuse and allegations of rape as well. At one of the subsequent hearings, there was an application made on behalf of the guardian to instruct an expert psychologist, Miss Melanie Gill, to undertake a specialist family assessment. It's important to note that Ms. Gill was unregistered and an uncharted psychologist. The court granted the application, and she was therefore instructed. The judge also set the matter down for a combined fact-finding hearing and welfare hearing. So the fact-finding hearing and the welfare hearing, the court heard oral evidence from Ms. Gill, the psychologist, only. So at the conclusion of her evidence, the judge asked that if the court were to find the allegations of physical abuse and domestic abuse in general proved, would her recommendation change? And she said that it would not, because her determination was affected by the hatred that mother possesses against the father. And therefore, her recommendation was that the mother was alienating these children from this father. The judge invited submissions from the parties as to whether the court should hear from any other witness. Counsel for the mother said that there should have first been a fact find to determine the allegations of domestic abuse prior to the expert being instructed and giving their report. And she said that the allegations made by the mother surely must have an impact on the shape of this case. However, the judge giving judgment, he accepted Ms. Gill's recommendations. He said that even if there was a fact-find hearing, even if these allegations were made to be true, she clearly stated that her recommendation would not change, and therefore he did not hear from any other party because he believed that it would not assist him in dealing with the actual issues in the case. And then the judge continued to make findings against mom. So these findings were that there was emotional harm, that she was unable to meet the children's needs, that she was vengeful because of her childhood, and that most importantly, she triangulated the children against the father, and that she actively alienated them from him. So after this fact-find hearing, there was subsequent hearings, and there was the final hearing, May 2020, where at that hearing, the judge determined that the children will live with the father and that they will have no contact with the mother until further order. Then the mother did not see the children for 5 years. In April 2025, the mother made an application under a Part 18 application to reopen and set aside those findings. So in those 5 years, she did try again to make an application, but the court said, nope, these are the findings, and did not reopen it. So this was finally in April 2025. She made Part 18 application to reopen, set aside those findings that were based on Ms. Gill, the psychological expert's opinion. In November 2025, the case was transferred over to the High Court. Mrs. Justice Levin, on the 27th of November, she discharged the child arrangements order, and then she listed the matter for a 2-day hearing before Sir Andrew McFarlane on the 29th and 30th of January 2026. So Sir Andrew McFarlane set down the modern approach for family courts when to use or how they should approach unregulated and unchartered experts. So this is the first issue that came out of this matter. So firstly, he said that only regulated psychologists should be instructed. He issued a firm guidance that firstly, expert psychologists must be HCPC registered or BPS charted. Only in exceptional circumstances may they be unregistered or uncharted. And if it is one of those exceptional circumstances, there has to be reasons that are recorded in a judgment. I know sometimes when you look at a CV, so it's really important when you do look at the CV of the experts to really look at their qualifications. Are they registered? Are they charted? Then he said, so this obviously reflects a significant shift towards enhanced rigor, transparency, and quality assurance when instructing experts. So that's the first thing that he established. Secondly, he summarized the modern approach to the assessment of alienating behavior as well. So he determined that where there is domestic abuse and parental alienation, allegations of both, then the court has to determine first the domestic abuse allegations. He said that the court should not investigate alienating behavior in isolation without first establishing the underlying facts. And then third, he said then the experts should not be instructed to assess alienation until factual background, including domestic abuse, is clear. He then, giving judgment, he granted Mother's Part 18 application. He set aside all the previous findings in order that the allegations would not be redetermined. In his judgment, he gave the following reasons: that the fact-find hearing should happen first before the instruction of an expert or before the final Section 7 report. In that case, the psychologist was not suitably qualified, as she wasn't registered or chartered, and she lacked clinical practice as well. The fact-find should have preceded the expert evidence. The court was in error in directing that the expert and guardian should file final reports, making their recommendations prior to the fact-find hearing. And finally, he determined that the decision by the judge at the fact-find hearing to hear the evidence of the expert first and to hear no other evidence before deciding that he accepted her analysis and recommendations was a fundamental error. So in conclusion, the judgment is highly significant development in the family court's approach, both to instructing experts and how to deal with allegations of alienating behavior. And like I said, everything will be in the slides if you do need to refer back to it. Thank you very much.
Thank you, Rebecca and Eva. The next speaker I'm delighted to welcome is Emma Coxon from CAFCAS. She is the Head of Practice for Learning and Development and is joining us to talk about CAFCAS and assessing domestic abuse.
Just check this is working. This is far more intimidating than speaking to the entire room. But hello, everyone. As said, Emma Coxon, Head of Practice for Learning and Development at CAFCAS. So as part of my role, I'm in charge of training, learning, pathways, best practice guidance, etc. But I also co-chair our national network of domestic abuse practice champions. So they are family court advisors that are embedded throughout the country in all of our teams. They have a bespoke learning package and they help drive forward our domestic abuse practice locally. I co-chair that network with two of our colleagues who are secondees from the Safe Lives organisation, who've been working with CAFCAS for the last 2 years, really, about really strengthening our domestic abuse practice and really sort of looking at that in detail. So, just to give an overview for you about us as CAFCAS, I know I've got some CAFCAS colleagues in the room as well, and I think I might have a couple of domestic abuse champions with us today as well, so that's good. So, obviously, we are independent advisors to the family courts in England, and we're there to sort of advise on the welfare of children, what's safe for them and what's in their best interests. So we act in accordance with the Criminal Justice and Court Services Act 2000 and report directly to Parliament, and we're an arm's length body of the Ministry of Justice. So it's our statutory responsibility to safeguard children and promote their welfare, give advice to the courts, make provision for children to be represented and provide information, advice and support to their children and families. I think just to sort of start off, you know, in terms of the way that we work, our Together framework, our Together practice framework, we heard earlier on about restorative practice in family group conferencing, and that very much underpins our relational practice model of Together. And that's really about our approach really to practice, not just with children and families, with our partners and within the organisation as well. So it's really sort of based on respect, empathy, understanding, building those relationships and being quite directive about how we assess risk, how we understand that, really considering a child and a family's uniqueness, what makes them special, and thinking about some of the tools that we utilise as well as part of that model, things like family storyboards to sort of talk to children about what might be happening for them. So it was developed collaboratively across CAFCAS and it was formally launched in September 2021. Our Family Justice Young People's Board, so for anyone who doesn't know, FJYPB, when you start at CAFCAS, I think it takes you a while to get that little acronym in your head, but that is children and young people who have been part of court proceedings, might be private, might be public, and they form our board of FJYPB and child participation. It's really well embedded in CAFCAS, and they advise on all sorts, and they're involved in all sorts, conferences, putting together kind of top tips for social workers. You find them in a lot of spaces, so they were involved as well in this. So I'm sharing this with you first today just to kind of set that scene really about how we go about our practice. So I just want to sort of take a minute. I'm so sorry about the slides. It's kind of moved over, but how children interpret and experience the court process. So how does it feel for them really? You know, we know that parental separation can be highly stressful for children and can have a big impact on their lives. And sometimes this impact can last well into adulthood. The court system should be set up to try to minimise stress and harm rather than add to it. So if you are a professional working with a young person who you know is involved in court proceedings, obviously it's important that you keep to mind the stress and confusion that that young person might well be feeling. They can often feel left in the dark about what's happening throughout their parent separation, the court process. In some cases, children know more about what's going on than what the adults realise, but they are not always given the accurate and timely information that they want. Sometimes there are attempts by adults to hide what is going on, and that in fact can cause more stress for children. So professionals should take an active role in ensuring children have access to information presented in child-focused ways. So if you're working with a young person, I've skipped back to that bit. Be aware, of what this process and what might be happening for them, and what you might then sort of see as a consequence in some of the behaviours. Many children want to be more involved in decision making, and there are different ways that children can be supported to share their views, and different children may want different things. There is an important distinction to be drawn between children wanting their views to be listened to and taken seriously, and children wanting responsibility for the final decision. As we know, in lots of areas of social work, children sometimes have to engage with lots of professionals, and especially that is true when their parents are going through separation. So professionals need to ensure these interactions are sensitive and supportive, and that they demonstrate an understanding of how serious these issues are for the children involved. Generally, children will have a really clear view about spending time in living arrangements, but they also need time and support to be able to consider these views, especially when domestic abuse is a factor. And we know that delay in proceedings heightens these risks, which is why it's important for professionals having an eye to delay in proceedings and the impact. Taking steps to mitigate this through effective planning, considering use of expert assessments to ensure any value is added, is balanced with the impact of the delay caused, and escalating with the court where necessary to move proceedings on. So, just taking a minute really to sort of consider the emotional, psychological and development impacts of parental conflict. So by very nature of the fact that families are in court proceedings and need that support to help decide on matters for the children, we obviously see high levels of conflict between the parents involved in private law proceedings. As with all forms of harm to children, conflict can vary in nature, intensity and impact. It is important for us to keep in mind the impact that conflict can have on children. As you can see set out in the slide, children being preoccupied with surviving the emotionally volatile climate in their family above other activities or priorities in their life, e.g. school or friendship. Children can feel confused, they might feel burdened by divided loyalties, feeling that maybe taking a side, might minimise conflicts. Living in conflict can lead to anxiety and depression in young people, with common emotions including anger, grief, sadness and guilt. Children may feel lonely. This may be due to feeling unable to talk about how they are feeling with those they love the most, or worrying about discussing what is happening with a friend or trusted adult. They might feel guilty, or they might worry that it might make things worse. You might see changes in a child's behaviour, heightened aggression, withdrawal, changes in appetite or disturbed sleep. And it's also worth noting that the impact of harmful conflict may be worse for preschool children due to sort of their age and the number and of sort of difficult developmental tasks that are happening for them at this time. CAFCAS uses the term harmful conflict to encompass sort of any level of conflict which is detrimental to a child's well-being, and sort of brings the focus of the impact onto the experience of the child. But it is important to sort of note that harmful conflict, parental conflict and domestic abuse are two separate things, and they shouldn't be conflated with one another. So they have different risks, they require different assessments and intervention techniques, but we'll come on to sort of have a little look at that later. So just to sort of bring it back to the child's experience really, because that's always sort of a good place to come back to. Just got some quotes here from, these are real children and sort of real feedback that they've given and their experiences really. So I just think it's quite powerful to kind of consider what their experience has been. I'll take that one at the bottom. The worst thing was my mum and dad slagging each other off on social media and everyone else getting involved. All my friends could see it too, and I didn't want to know all that detail. So I think we forget sometimes, don't we, about kind of how that might feel for them. And the first one there from Maddie is about kind of actually going to meet her CAFCAS family court advisor and the stress of sort of folding and unfolding the paper, which I think is quite a sad little visual, isn't it, to sort of think about the level of anxiety she must have been experiencing in that moment. So, you know, when we're talking to children about what they want or what their experiences have been, you know, it can have a really big impact. So, it's happened again, I'm so sorry if the slide's moved over, but it's trauma-informed approaches for practitioners supporting affected children. So, of course, it's really important when we work with children that we do so in a trauma-informed way, especially when they're living with conflict, and indeed, really, all of the children that we work with. So ways by which we do this is amplifying the child's voice above adult conflicts. That's a fundamental task. The CAFCAS direct work practice aids can be used to work sensitively with each child. It's important in the assessment when it's carried out with the child rather than it being done to them. Practitioners should let the child know how their views will be shared with their parents and ensure they are comfortable with this. Also considering whether we can help them explain their own views to their parents. Always also keeping in mind whether there are any factors impacting on the child's ability to express their wishes and feelings. If so, CAFCAS should make appropriate arrangements to facilitate this. For example, involving a school counsellor or another trusted adult, and also utilising CAFCAS's guidance on assessing children and young people's wishes and feelings, which can also be found on the CAFCAS website. If a child is working with agencies to support their emotional well-being or mental health, for example, school or CAMS, then it will be important we speak with them to obtain information prior to our engagement with a young person wherever possible, as this will support our approach to doing things in a planned way and best supporting that young person to feel comfortable and safe during the direct work. Respectful, child-centred practice requires us to report the child's views in full and directly, using their own words where possible, and allow them to be seen and heard in the court arena as directly as possible. This may include ensuring their direct work is embedded into a report or by supporting the child to write a letter to the judge if this is appropriate. We aim to ensure we can advocate for the child whilst empowering them to find their own coping strategies and who they can find as a trusted adult, such as a teacher or wider family member. This is particularly important given CAFCAS's time-limited piece of work, and we are in a position to offer, we're not in a position to offer any ongoing support from CAFCAS once proceedings is concluded. So looking for who can kind of take that forward. And you can see in the purple box there a link to sort of our, that one's indicating conflict, which is harmful to the children, but also takes you through to our CF. I'll talk about CF a little bit more, but there's a range of resources there that's available to anybody from any organisation, externally to CAFCAS. You can go on there and you can find a wealth of them. We have recently undertaken quite a big piece of work of stripping away some things that aren't utilised much or might have been quite old now, and we're doing a current piece of work about some of those gaps and things that we might want to look at. So, for example, working with children with neurodiversity is one of the things we're working on. It kind of links back to this about getting the wishes and feelings of children, but being really sort of sensitive to their individual needs and how best to sort of do that. So, safeguarding and risk assessment in private law. So, it isn't the role of CAFCAS to investigate immediate child protection concerns or provide interventions to children and families. I think sometimes because we're social workers, people make an assumption that that might be part of our role. Our remit in private law is to complete an assessment in order to make safe recommendations to court. And if we're completing a Section 7 report, we would normally interview both parents and then meet with the child once or twice. We're not regularly visiting them. The risk assessment we complete depends on the interim arrangements being safe. For example, the child not seeing the parent who may pose a risk while we are completing our report. If the risk changes, so for example, if a child starts spending time with the parent who may pose a risk before it's been completed, we would then need to consider making a safeguarding referral and inform the court via a risk assessment. So, as people may well be aware, a 16A risk assessment. So what really surprised me kind of coming into CAFCAS was the number of private law families that we work with in comparison to public law, but actually that over half of our private law families feature domestic abuse. So obviously we have to be very sort of in tune with what the risk factors are there and our own sort of assessment ability. So put here then, this is the government definition that is used across all departments, including the Ministry of Justice, and the definition of domestic abuse is set out in Practice Direction 12J. So just to sort of note that there was a change from financial abuse into economic, sorry, I couldn't find the word in economic, and that was to kind of recognise that actually financial abuse can take a much broader form. And there is a little bit of tension, I think, around 16, 17, because obviously it's from those aged 16 above, but children's social workers may often be working with 16, 17-year-olds and still as children, but kind of within the law, sometimes in this context, seen as perpetrators. Again, these and the slides, I think there will be links to sort of fact sheets around that. And then looking a little bit at kind of the different forms of domestic abuse, coercive behaviour, controlling behaviour. And I think this is an area, I've been at CAFCAS now over 18 months, that I think there's a lot gone into kind of understanding coercive and controlling behaviour and understanding that obviously domestic abuse is not just physical. Coercive control is deliberate, patterned and anchored in one person's strategic use of power to subordinate the other one. Coercive and controlling behaviour involves a sustained course of conduct designed to create fear, dependency and compliance. It is less about the physical incidents and much more about the pattern limiting someone's freedom, undermining their autonomy and reshaping the family environment around the perpetrator's rules. Control may be exerted through isolation, financial restrictions, intimidation, micro-regulation of daily life, monitoring or threats, and the behaviour often becomes the background noise of family life, affecting every decision made in the household and significantly impacting children's emotional safety, sense of stability and capacities to form secure relationships. Children that live with coercive control do not just witness abuse, they live within a system of fear, unpredictability and power imbalance. Their behaviour may appear compliant, avoidant, hypervigilant or parentified, not because of a single incident, but because of an ongoing climate in which one parent's dominance shapes the whole family's dynamic. And looking just closer then at the post-separation abuse and litigation abuse, which is two sort of forms of domestic abuse that I think that we encounter at CAFCAS and sort of have that awareness and understanding of in practice. So it's quite common to think that risk reduces to victims, including child victims, when abusive relationships end, but this is often not the case. In fact, for many victims, the risk of domestic abuse actually increases after separation. So post-separation abuse can be particularly harmful to children who may be used as tools of control. Victims may face ongoing fear and trauma even after physical separation. Post-separation abuse is often overlooked or minimised. Practitioners must assess its impact on both the adult victim and the child victim. Emphasise that children are not just caught in the middle, that they can become active conduits for ongoing control. For example, we might see manipulation around handovers, making children feel responsible for carrying messages or reporting back, undermining the other parent through the child, using contact arrangements to exert control, reinforcing that for children, post-separation abuse can feel like the abuse never ended, even if they are no longer living with the perpetrator. It can be commonly missed because the abuse is no longer happening in the home, and the behaviours take place in the context of child arrangements or legal processes. So sometimes it ends up being conflated and seen as high conflict rather than coercive control. And litigation abuse, this drains the victim's finances. Just heard from the previous one about that poor lady that was put through that process 14 times, I believe. It causes severe psychological distress and can force protective parents to capitulate or return to their abuser to avoid that. The Domestic Abuse Commissioner is calling for wholesale change in the family court, which is a welcome summons, not least because family law litigation can sometimes amount to abuse in its own right. This can place victims and their children at very serious risk of continuing harm, which is the opposite of the culture of safety and protection from the harm, which the family court should embody. So just a little, sorry, I'm forgetting about the mic, little bit of context here as well, legal context. The Domestic Abuse Act 2021 recognises a child as a victim of domestic abuse if they see, hear or experience the effects of domestic abuse and are related to or cared for by an adult with parental responsibility who was the person being abused or the perpetrator of the abuse. And I think that is an area of practice we're really focusing on now in CAFCAS, is recognising and responding to victims as, to children as victims of domestic abuse. And I think sometimes you see people can really talk about the impact. They might be able to sort of pull out some of that behavioural detail, but not necessarily making the link that actually it's not just that they are sort of bystanders, they are actual victims of the harm that is happening within that home. And then obviously we have Practice Direction 12J. This is part of the Family Procedure Rules from 2010. It sets out what the family court should do in any case in which domestic abuse is alleged or admitted, or there is other reason to believe that the child or party has experienced domestic abuse or abuse perpetrated by another party, or there is a risk of such violence or abuse. So Practice Direction, or PD 12J, gives the legal context in which a court may direct a fact-finding hearing, and the role of CAFCAS in this decision. The court must decide whether it is necessary to direct a fact-finding hearing about disputed allegations of domestic abuse or abuse for the following reasons: to provide a factual basis for the welfare report under Section 7 of the Children's Act 1989, to assist the court's assessment of the factors in paragraphs 36 and 37 of PD 12J, to provide a basis for an accurate assessment of risk of harm, before it considers any welfare-based orders around child arrangements, and before it considers the need for a domestic abuse-related activity, such as attendance at domestic violence perpetrator programme. So it's essential reading when completing reports of a court and where domestic abuse is a factor, and it also provides guidance around when it is safe for courts to make orders or not make orders. So we, as part of our domestic abuse training, this year launched a PD 12J training, very, very heavy training. It's a full-day training if any of my CAFCAS colleagues have been on it, but it's an incredibly informative and useful one. So then just in general what we have at CAFCAS, so we have the Domestic Abuse Practice Pathway. So that was first created in 2016 as a framework to facilitate our assessment of domestic abuse, and then it was updated in 2021 in line with learning and feedback, moving away from more of a task-based framework to one that uses more of a questioning approach, one that prompts reflection and consideration of the key issues within domestic abuse risk assessment. Both the pathway and guidance were developed with input from a range of partners, including an internal reference group of practitioners and managers, our National Improvement Service, the policy team, external partners such as the FJYPB, Safe Lives, Women's Aid and Families Need Fathers. So the guidance, our domestic abuse practice guidance, is a thematic document that pulls together messages and learning from relevant literature and research, the knowledge base in respect of domestic abuse, which is vast. We're trying to support practitioners to navigate that and select material that is credible, reliable, grounded in social work practice and values, and always stays with the child at the focus. We have our CF that I referenced earlier on, our Child Impact Assessment Framework, which is just a wealth of kind of practice aids, guidance, tools across a wide range of sort of risk factors, but there is quite considerable amount of things that are available to practitioners around domestic abuse to support with assessment, a number of practice aids that they can look at. Some of the themes we've talked about today, is it high conflict, is it domestic abuse, etc. So these are all the things that kind of pull together really to sort of form part of that for practitioners at CAFCAS. And I'll just sort of touch on the domestic abuse practice policy. It's far too long for me to have included it in the slides today, but this came out in September 2024, and then there was a sort of rewrite of it in March, April 2025. We've reviewed it subsequently, but it is as it stands, but it's a really detailed document that sort of sets out expectations for family court advisors and guardians around how they approach domestic abuse, what to look out for, you know, what the requirements are really, and just sort of, I guess, stating CAFCAS's commitment to domestic abuse practice. And I would say that, you know, we've seen significant improvements in domestic abuse practice. We have quite a lot of audits that happen, but we have what we call a practice quality audit. We have thematic ones, and we have a domestic abuse one once a year that takes in over 200 child records to look at, and the findings from that have just sort of been released, and it's, you know, significantly better picture than last year. So we are seeing all of these things kind of coming together, really having an impact. But if you get the opportunity, if you haven't sort of looked at it before, please have a look at the domestic abuse practice policy, because I think it really sort of outlines CAFCAS's approach and its approach to sort of working with victims, really, the language that we use, the sensitivity that we bring to that situation, and understanding the trauma that's involved for people that have been through those circumstances. Just very quickly, this is our domestic abuse risk assessment. I say very quickly because I know everyone will want their break at past. But yeah, these are the sort of 5 stages that we go through when looking at this as part of the assessment. Identify the nature, duration, impacts and severity. Identify who the child feels safe with. Assess the harm and the impacts of the domestic abuse on each individual child. Building on that analysis, assess the likelihood of continued harm and provide the court with a clear, evidence-based and well-reasoned recommendation in accordance with the child's best interests. And then lastly, just to finish on, is an example from our CF of one of our practice aids that our family court advisors use throughout their process, and just sort of gives a little bit of a flavour. As I say, it's kind of one of many. This is the What We Need to Know document that they might take out and sort of fill out with people involved. So that's me. Thank you.
Thank you, Emma. That was super. Next, it's coffee break, folks, for 15 minutes. So grab a cup of tea or coffee, and then we're on to financial remedies. Thanks. Thanks, everybody. So the next speakers from Fenners Chambers are Laura McGinty and Richard Bolchin, who will be addressing financial remedies. First up is Laura McGinty.
Right, hello everybody. Thank you for still being here on a very hot and very sunny afternoon, particularly on a Friday. Richard Bolchin and I are covering the financial remedies update this afternoon. Richard gave a case law update, an online seminar in March of this year, and he covered a number of recent cases during that seminar. The recording is available online, so I won't go through those cases again. I've listed them on the slides, along with the link to the Chamber's website if you want to access the recording. So this afternoon, I've picked 3 cases to cover, which I thought were of interest over the last 12 months, and then Richard has some further cases to follow. The first case is BS and HC. Those of you who are fans of the TV series Friends will know that they name their episodes The One Where. So I've adopted that for this case summary, and this is the one where matrimonialisation of pensions is considered. Not quite as catchy as the Friends titles, but it gives you an immediate insight into what this case is all about. So, You've got the facts on the screen there. The important part to note is that the husband had very significant pension provision, over £3 million, and the wife had very modest pension provision, about £35,000. The case came before His Honour Judge Hess, pensions guru, in January of this year. And the issues at that final hearing were related to the pensions. Firstly, the parties couldn't agree how much of the husband's pension provision was matrimonial. And secondly, the wife asserted that the non-matrimonial element of the husband's pensions had been matrimonialised. And it was that second point, the matrimonialisation point, which attracted my attention, and it's the reason why I've chosen that today to talk to you about. But let's first look at the apportionment issue. The difficulty in this case was working out what could be said to be matrimonial, and the court described a complicated and an unusual chronology, which I'll set out as briefly and simply as I can. The husband was the director and the CEO and shareholder of a company. That company had a defined benefit pension scheme, which the husband joined in 1988. The parties married in 2009, and in 2012, the pension scheme closed. That's to say, accrued rights up to that date continue to exist, but no further rights accrued after that date. So the husband was an active member of that scheme from 1988 to 2012, a period of 24 years, and only the final 3 years fell within the marriage. You can do the maths, but the first 21 years were all outside the marriage. Now, at first glance, you might think that means only a small part of the pension could count as marital, but it wasn't as straightforward as that. The parties instructed a POD. He assessed the value of the husband's pension in 2009, the start of the marriage, at £180,000. But by March 2021, that same pension had risen to over £2.2 million. Why had there been such an enormous rise in the husband's pension? Particularly, as you'll remember, the pension scheme was closed to further accruals since 2012. Well, the answer is that in 2009, when the pension was valued at £180,000, it was underfunded, i.e. there wasn't enough money in the pot to cover the pensions that were going to have to be paid out, and that was reflected in the low value of the pensions at the time. During the marriage, the husband's company made very substantial payments into the pension scheme, between £1 to £2 million every year, to try and address the underfunding, and it meant that the value of the husband's pension skyrocketed. But there were also other factors, global economic factors, and some changes in the underlying methodologies in the way the pensions were calculated. The POD looked at pension apportionment, and he calculated it in 2 different ways. Well, in fact, 3, but no one was interested in the third one, so 2 ways of relevance. Firstly, if you looked at the husband's years of pensionable service, only a very small slice, 14.4%, was marital. But if you looked at the change in capital value over the course of the marriage, almost the entire pension, 91.5%, was marital. No prizes, I'm afraid, for guessing which position that each party favoured. The court effectively said, well, both methods are legitimate. Both methods are consistent with the valuation method set out in PAG. But you can see they produce completely different results. And the POD said, not a matter for me, that's a matter for judicial determination. So it came before Judge Hess, and faced with those 2 very polarised extremes, he reminded himself of the case of Hart. You've got the reference on the screen there. He said, the case of Hart said, in arriving at this determination, the court does not have to apply any particular mathematical or other specific methodology. The court has a discretion as to how to arrive at a fair division and can simply apply a broad assessment of the division which would affect overall fairness. Finally, I would repeat, fairness has a broad horizon. So that's what His Honour Judge Hess had in mind. And he said, a mathematical analysis is helpful, it's important, but the search for fairness requires a broader weighing of the competing arguments. There are some cases where one or other of these formulaic approaches might be fairer, but in this particular case, there were aspects of both parties' positions which should fairly be taken account of, and he decided that a middle ground option between the two options put forward by the Pode would be fairer. And ultimately, he concluded that treating 55% of the husband's pensions would be the fair outcome in terms of what should be matrimonial. And those of you speedy with your mental arithmetic will note that that's almost exactly halfway between the parties' two positions. And Judge Hess felt that 55% of the husband's pensions being matrimonial balanced the significant growth that there had been during the marriage because of the cash injections against the fact that most of the underlying pensionable service had happened before the marriage. So now, onto the second issue that this case brought up. Could any of the non-matrimonial element, which we now know is 45% of his pensions, be said to have been matrimonialised? And the wife asserted that the whole of the husband's pension should be treated as matrimonial, and that came from a specific conversation that the parties had had in 2013, in which the husband had reassured the wife that they would share everything equally. At the time, she had just received 1.5 million in an early inheritance, and she was looking to put that money into a second home, and the husband was trying to persuade her that that should be held in joint names rather than her names. And in doing so, he said to her, it doesn't matter that I'm not contributing towards this property because we'll share everything equally. Everything is going to come into and out of the same pot. And the wife relied on that to say, well, he was talking about his pensions as well. So we treated everything as being matrimonial and pensions should be the same. At trial, the husband said, no, I wasn't talking about my pension. He said, I had company shares, which are actually about the same sort of value as the wife's early inheritance. And he said he was referring to those. He was happy for all of the capital in the marriage to be treated equally, but pensions, he said, were different. Now, you'll all know matrimonialisation is something that was carefully considered by the courts in the case of Standish. And you'll remember that we had the Supreme Court judgment in that case last year, and that approved the concept of matrimonialisation, i.e. a non-matrimonial asset turning into a matrimonial asset. And in short, the Supreme Court said, matrimonialisation rests on the parties over time treating the asset as shared. And the relevant extract for the Supreme Court judgment is included in the slides. You've got that there if you want to refer to it afterwards. For some assets, matrimonialisation might be pretty clear and obvious for us to see. You might have cash that's put into a joint account. You might have inheritance that buys the family home. You might have a property put into joint names. Those are all things that are pretty easy for us to identify. But what about pensions, particularly when the parties are pre-retirement age? Could they be matrimonialised? That's exactly what His Honour Judge Hess was dealing with in this case. And this is what he said. Rights in a pension, unlike cash or property, rarely become mingled during a marriage. They remain in the sole name of the person who earned the pension rights. That's just a feature of how pensions are held. They're never put into joint names. Whereas here, the pension rights have not been drawn down at all, then they remain an unmixed and an unutilised asset, but the source of future income. What does it take for it to be fair to treat such an asset as having been matrimonialised? Now, the husband argued that since his pension fund had been untouched, he wasn't yet at retirement age, it couldn't meet the Supreme Court test in Standish because it hadn't yet translated into actual use and enjoyment. But His Honour Judge Hess concluded that that was too literal an interpretation. And he said, a common intention to put that asset, i.e. the pension, into use and enjoyment in the future could also, in his view, give rise to matrimonialisation if that intention was relied on to the other party to their detriment. And the example he gave was that if one spouse said to the other, words to the effect of, if I contribute my £1 million of cash to purchase a property in joint names, will you agree to treat your £1 million in your pension as a joint asset, even if it remains held in your name? And Judge Hess said, well, if the other party agreed to that, then notwithstanding the fact that the pension's not yet been put into actual use and enjoyment, that would amount to matrimonialisation in his view. And he said a different conclusion would just not be fair. But in this particular case, there hadn't been any specific conversation regarding the husband's pension. It was a general conversation, and His Honour Judge Hess concluded that there needed to be more to meet the Standish test. So the wife's matrimonialisation argument failed, but the crucial takeaway is that it failed not because pensions can't be matrimonialised. It failed because the wife's evidence in this particular case was not sufficiently specific. So the judge concluded that only the 55% of the husband's pension was matrimonial. That needed to be shared equally between the parties. And then the wife tried to raise a needs-based claim for pension sharing extending to the non-matrimonial part, and that just didn't get off the ground because the sums in this case meant the judge wasn't satisfied that she had any need that went beyond the sharing element. The last bullet point there reminds us that judgments at circuit and district judge level shouldn't be cited unless they contain the express statement that the judge intends them, the judgment to be citable, and this case has that certification, so we can cite it. Now, what lessons can we take away from this case for our own practices? Well, firstly, it tells us that when we're looking at apportionment, it's not necessarily just the mathematical exercise of relying on the figure we get from the code. The court also has to take into account fairness too, and that might be useful for us to have in mind in the appropriate case. But really the standout aspect of the case is the way it deals with matrimonialisation of pensions. We now have the authority telling us pensions can be matrimonialised, although we know if you are going to try and launch an argument in that respect, you're going to need to have really specific evidence that the intention related to pensions. Lastly, this is all very interesting, well, interesting in the context of financial remedy cases, but while you can of course raise these arguments, the court's likely to decide that most cases are needs cases on pensions, and in a needs case on pension, the court can have recourse to any of the pension, regardless of the source, to meet needs. So actually, although these are academically interesting arguments, you might find in the run-of-the-mill case that you deal with in relation to pensions, these aren't arguments that probably get past an FDR. So, case number 2, Silberschmidt and Richards. I chose this one because it had a really satisfying sense of karma about it. I've called it the one where the husband reaped what he sowed. And I'll come on to the details in a minute, but essentially the husband had fraudulently failed to disclose material information during the parties' settlement negotiations. Years later, he met the wife and gloated to her about that, telling her she shouldn't have been so trusting. And in response, lo and behold, she brings an application to set aside the final order. And he then tried to raise a procedural defence that she'd waited too long to try and set aside the final order and that her application should therefore fail. And that's what this case deals with. So, background. Case was settled in December 2020. In July 2021, the wife received some documents from an unidentified informant relating to the husband's company. It's a director's report and an email that he sent to investors. And seemingly the content of those documents must have been completely at odds with the disclosure that he'd given in the course of the settlement negotiations. The wife consulted solicitors at the time. This is back in 2021. She consulted them in July and separate solicitors in November, but no action was taken. In April 2023, the parties then meet at a restaurant and the husband's company came up in conversation. He told her that she'd been too trusting in the divorce and maybe you've now learned a lesson. And those were remarks what prompted her to engage solicitors, and then the application to set aside flowed from that. Her application was listed for a 4-day final hearing before Recorder Chandler Case C last year. The wife's case was that there had been material non-disclosure and that the final order should be set aside. The husband's case was there hadn't been any material non-disclosure, and in default that the wife was out of time to make any challenge to the final order because the evidence that she relied on to bring this application in fact came from the documents that she'd been sent in July 2021, and so she'd been too slow to act on that. The judge at first instance made a range of findings against the husband of deliberate non-disclosure and fraudulent conduct. The judge rejected the husband's arguments about the wife's delay. He was satisfied that the clock only started running in April 2023, this meeting in the restaurant, because that's when the penny had first dropped for the wife, that the husband was guilty of the non-disclosure. She hadn't realised the true significance of the documents in July 2021, and the judge accepted that these were really complicated issues to dealing with the husband's company. But with some fortuity, he went on to say if he was wrong about that, and the date did run from July 2021 when she was sent the documents, then he was still satisfied that her application to set aside the final order should proceed. And he noted that in 2021, she'd been in a state of what he described as personal turmoil, dealing with various issues, and he considered that should weigh in the balance for the court to stretch its discretion to allow her application to proceed. And accordingly, he set aside the order. Now, you might think that the husband would have taken that decision on the chin. He was caught out as a result of his own gloating. He'd gone through a lengthy trial process, 4 days of a final hearing, lots of evidence and lots of findings made against him. His actions have caught up with him. But no, he doubles down and he appeals. He's refused permission to appeal in respect of the underlying facts, so he can't challenge those. But he was given permission to appeal on the ground that the judge had misstated or misapplied the law relating to the wife's date of knowledge, the assessment of her delay in acting, and the principle of finality. And that appeal was heard by Mr. Justice Poole in October 2025. The issue in that appeal was whether the delay in bringing an otherwise meritorious application to set aside a final order, specifically for fraudulent non-disclosure, could be fatal to the application, and if so, how does the court determine whether any such delay is fatal? Mr. Justice Poole accepted that there's no limitation period on making an application to set aside a final order that's set out in statute or in the procedural rules, although he did note that Practice Direction 18A, paragraph 4.6, it's the middle bullet point, says that every application should be made as soon as it becomes apparent and that it's necessary or desirable to make it. But that's as far as the procedural rules go. But he then conducted a detailed review of case law, and he was satisfied that that had established the need to apply with reasonable promptness. At paragraph 80 of his judgment, he sets out a very useful summary of the applicable legal principles. So if you need to ever, and you always hope that this isn't ever going to happen, but if you ever need to apply to set aside a final order because there's been fraudulent non-disclosure, this is where you're looking at. So number one, the applicant must act with reasonable promptness in making the application. The court must determine whether a lack of reasonable promptness should defeat the application. 2, the assessment of reasonable promptness requires consideration of all the relevant facts and circumstances in the case, and that includes subjective and objective factors, which include the nature, the extent, the effect of the fraudulent conduct, consideration of the information available to the applicant, and what they knew or could have known with reasonable diligence, the period of the delay, and the impact of the delay on the other party, on fairness, and on the administration of justice. And that includes looking over the whole relevant period, so before the information came to light and after. And ultimately, in this case, Mr. Justice Poole found that there were some errors in the way that Recorder Chandler KC had approached the case. And the most important error was that Mr. Justice Poole considered the date should not have been taken for the wife's knowledge of the husband's non-disclosure at 2023, this meeting in the restaurant. It should, in fact, have been July 2021 when she was sent the documents, because those documents were the foundation that her application to set aside was subsequently based on. But because Recorder Chandler KC had already dealt with the 2021 position in the alternative, that paragraph where he effectively says, well, if I'm wrong about it being 2023 and it's actually 2021, then I'd still allow her application, it meant it wasn't fatal. Mr. Justice Poole noted that even though the clock had started running for the wife to make her set-aside application in July 2021, there wasn't any evidence to show that the delay of 23 months had caused the husband or his company any prejudice at all. The errors that were there didn't materially affect the decision under appeal, and the appeal was dismissed. So, what do we take away from this case? Well, the judgment makes clear from the point that your client comes to you and they tell you that they think there's been non-disclosure or there's been fraud, the clock is potentially running. So you need to act promptly, and the test, of course, is reasonable promptness. And if you don't do so, or your client doesn't do so, it's not necessarily fatal. It's going to be weighed against all the other factors. And of course, one of those factors is the fraudulent non-disclosure itself. Now, the third case that I had, I'm not going to go through because we're out of time, but it is a really good one. So I'll just tell you briefly about it, and then you can go away and look at the slides if you want in your own time. It's a judgment dealing with the wife's application for financial remedy 22 years after the parties divided their finances by agreement. So I've called it the one where the wife tries her luck 22 years later. It was a 9-year childless marriage that ended in 2000, and at that point the parties settled their finances, divided everything equally, all straightforward. They agree a consent order, which they think is sent to the court and they assume is sealed, and they both act upon it. And it later transpires, over 20 years later, that in fact it hadn't been sent to the court, or if it was, it got lost and it hadn't been sealed. And so financial remedies are left open. Now, at the point the parties settled their finances, they had very modest assets, about £300,000. 22 years later, the wife has very modest assets. The husband's assets are in excess of £100 million. Now, the husband, this is the juicy element, the husband has a business acquaintance who is a malicious influence, it's described in the case, and he befriends the wife. The wife is described as vulnerable, susceptible to influence. The husband's business acquaintance befriends the wife, entices her to believe that the husband had fraudulently deceived her back when they settled their finances 20 years earlier. He encourages her to initiate litigation that he's prepared to fund. And actually what the court decides he wants out of all of this is he wants, A, to disrupt the husband and his company's affairs, but also he wants the husband's financial disclosure. So there's a nefarious influence there. Anyway, the case plays out. It's all quite juicy and quite interesting. There's a touch of EastEnders about it all. And after all of this, the court decides, no, you reached an agreement in 2021. The wife raises lots and lots of arguments to try and disrupt that agreement, undue prejudice, lots and lots of things. And the court says, no, nice try, but no, you reached your agreement, you're stuck with it. One of the really staggering points of the case is that the parties between them end up spending £2.13 million on costs arguing this point. By the point it reaches final hearing, the wife is asking for 2.63 million from the husband. So you get the point about proportionality. And I'll quickly skip through to the last slide. Oh, gone too far. Oh well. Proportionality is a lesson to take away from this, but also is the way that you approach your cases. So the wife's solicitor, when first instructed and realised that the financial remedies application was open to them, wrote to the husband in a way that was described by the court as being thoroughly inappropriate and hostile. The husband hadn't heard from the wife for years, and the wife's solicitor went straight in and said she wants £10 million from you, she wants financial disclosure within 14 days, and a raft of undertakings from him that he wouldn't dispose of assets. And the husband inevitably got his back up and said no. And in his cross-examination, he said that he felt sorry for the wife, and had she approached him other than through lawyers, he would have given her some money. And you know, when you look at the papers, he spent nearly £2 million in costs. So it's a really important lesson to take away. If you get somebody come to you with perhaps not the strongest case in the world, you might take a view about how you approach that case rather than going in really bullish from day one. Anyway, the notes are all there on the slide if you want to refer to them afterwards. Thank you very much for your time.
Right, good afternoon. Where's everyone gone? As we're an exclusive bunch here, let's have a bit of fun. Put your hands up, please, if you've ever used artificial intelligence to digest a file. Put your hands up if you've ever had a client who's ever used artificial intelligence to tell you what they think their case is about. Put your hands up if anyone on the other side, litigant in person, has used artificial intelligence to tell you what you're doing wrong. Well, we're going to start outside the Financial Remedies Court with the case of UK and Secretary of State for the Home Department, an immigration case, the Upper Tribunal, Immigration and Asylum Chamber. Yet another one of those cases where junior solicitors have not been properly supervised, and they come up with a load of hallucinogenic citations and get mightily rebuked. The important lesson from this case is that if you upload confidential documents into an open source AI tool such as ChatGPT or any one of the others, it places the information on the internet in a public domain, and thus, in this context, breaches client confidentiality and waives legal privilege. So just think about all those clients of yours who have put their documentation up online. Have they or have they not waived legal privilege? And what are the consequences of doing so? And what are the consequences for you? Are you professionally embarrassed as a result of them putting their paperwork up on the internet in breach of those rules? Not just that, of course. Section 12 of the Administration of Justice Act, it's a contempt to publish any information relating to certain family proceedings, and publishing means putting up onto an artificial intelligence portal. And in addition, Section 97 of the Children Act makes it a criminal offence to identify a child. Of course, what goes up on the artificial intelligence portal is public domain. So when you're rifling through your co-pilots, please make sure it is secure and it isn't open. But also bear in mind the inevitability of the question, how does your open source AI actually learn anything if it isn't actually thinking out loud? Let's move on to another topic. The most exciting development this year is, of course, the Financial Remedies Court Guide. Now, it took the Chancery Division, now no longer the Chancery Division, about 600 years to come up with the Chancery Guide. It's taken the FRC about 5 years to come up with its guide, and it is described as essential reading by Mr. Justice Peel and His Honour Judge Hess, something you should keep on your desk at all times. It, of course, includes all the statements of efficient conduct, first principles, the bundle rules, the allocation guidance, and the like. And what it is intended to do is provide essential practice guidance for legal representatives, litigants in person, and the judiciary. And paragraph 3 says this, I don't know how many of you actually do this, legal representatives and the judiciary are encouraged to draw attention to this guide to any litigants in person who might not otherwise be aware of it. We'll come on to discuss costs in due course, but if you've signposted and sent a copy of this guide to a litigant in person, they can't, with all seriousness and with a straight face, claim they weren't able to follow the simple rules set out in that guide. Attached to the guide is, of course, another document that you should really be sending to litigants in person, or perhaps to your own client when they run out of money and have to go LIP. The Preparing Court Bundles for Family Proceedings Guide for Litigants in Person, dated the 2nd of March 2026, which sets out in exquisitely simple detail what should be in a financial remedies court bundle and what shouldn't be. Earlier, it was said that position statements were limited to 3 pages, of course. That was in non-FRC work. In respect of the FRC, the position statements are set out in detail as to what needs to go in them and the number of pages, which is substantially more than 3 pages. Bundles I've just dealt with. Conduct. You may or may not know that there is currently a government consultation called A Fairer End to Relationships that is open. It began sometime in June. It ends sometime in August. And I would suggest, if you read it and you're remotely interested in what comes next, you pay particular attention to questions 11, 12, 13, 14, and 15, because that deals with the government's invitation to members of the public, pressure groups, judiciary, legal practitioners, to send in your comments as to the extent to which conduct should be taken into account in the future with respect to unmarried relationships. And the suggestion, the inevitability, I would suggest, that there is going to be some form of new Family Law Act enabling the courts to divide the assets of unmarried couples in more or less the same kind of way we divide the assets of married couples. The whole tone of the document is, I would suggest, we need to take conduct far more seriously in terms of domestic abuse, in terms of economic abuse, and the like. And there is specific reference to the discussion, the ongoing conversation, should conduct be limited to the GASP test or the GULP test? And I would suggest the implication of the consultation document is we are going to be told at some stage that we have to take conduct more seriously in terms of a specific issue within the division of matrimonial and non-matrimonial assets. That probably doesn't come as any surprise. Mr. Justice Cusworth has been, I would suggest, at the forefront of leading the way. You will recall a case I did on the webinar, LP and MP, earlier this year. The wife lied to the husband that she was a High Court judge. Now, that wasn't the sole reason her sharing claim was reduced by 40%, but I hazard a guess it played a part in that. It's all about economic control, domestic abuse in its broader context. And in the sharing claim, the wife, who was obviously as guilty as sin, had a loss of 40% as a result of that conduct. That's the pathway we're going in. So we've lost the whole fault divorce-based arrangement. We've tried for the last 30 years to keep conduct out of the FRC or its predecessor. But watch that space. I think it's coming back. Death of a party. Well, what happens when your client dies midway through a divorce case? Canabar and Canabar sets out a guidance for what you need to take into account. I'm not going to run through, in any of the cases I'm going through, all the nitty-gritty detail, but give you the key principles to help you remember that case at the forefront of your mind at some stage over the next year or so, if it comes back to bite. Well, in this case, the appeal, as it was, had to be dismissed because after issuing an appeal, the person had died, the appellant had died, no personal representative in the wings, case falls by the wayside. But there is no general rule that where one party dies, the suit abates. It all depends on the specific circumstances. A substantive claim, if it hasn't got to the point the pinch point that you're going to have to look at on an individual case-by-case basis, is probably impossible to pursue. But death doesn't entirely end the MCA jurisdiction. Enforcement, obviously, a different issue. Death, of course, being the classic Barder circumstance. Unfair hearings. Mr. Justice Harrison in P&M, well, the wife was refused permission to cross-examine. I'll start again. The wife contended after the event that she had had an unfair hearing as she wasn't permitted to give oral evidence. Findings were made when her evidence had not been challenged. The court had answered questions put to the husband, and the judge had repeatedly interrupted cross-examination. I can't believe it. In this case, the husband said, well, I had no questions to put, so the wife didn't need to be actually called to go in the witness box. But Mr. Justice Harrison, in this judgment, goes through the problems that the judiciary face in such a scenario. It highlights the problems of the Domestic Abuse Act, the need to deal with qualified legal representatives and call the case back if one is not appointed for further directions. But the meat of the issue is what happens if you've got a situation where there is an inadequate cross-examination by a litigant in person, or by a QLR, or indeed by a lawyer. FRC cases are quasi-inquisitorial rather than purely adversarial. And the guidance is, even if you don't necessarily go through the full process of cross-examination, judges could, perhaps should, invite a witness or a party outside the witness box to comment on the proposition that an aspect of their evidence is being challenged, rather than simply leave it to one side. The old 1894 Brown and Dunn case, which deals with adversarial justice and the integrity of cross-examination, the purpose of cross-examination, was, as it were, upheld as part of Mr. Justice Harrison's judgment. But leaving aside the cross-examination point, judicial interventions have also been highlighted in this case. Well, in submissions, there were 42 such interventions by the judge at first instance. Of course, we're all used to that. It helps us hone our discussion, our argument. But as was said by Lord Justice Baker in K&L from 2023, there remains a danger both at first instance and on appeal that excessive intervention may prevent counsel advancing their client's case, while closing submissions offer the judge the opportunity to test the case being put forward. This should not descend into an argument. The purpose of submissions is for counsel to persuade the judge that her client's case should prevail, not for the judge to persuade counsel that it should not. Well, in that particular case, Mr. Justice Harrison found that the fairness of the hearing had been completely compromised because of the judge's interruptions, and the appeal was granted on that basis alone. Non-disclosure. MK and SK, Mr. Justice Appeal, reminds us all of some pretty simple, straightforward principles. The MOA rule, courts are entitled to draw adverse inferences as justified having regard to the nature and extent of the party's failure to engage properly with the proceedings. This doesn't require the court to engage in a disproportionate inquiry, nor does it encourage or allow the court to engage in pure speculation. Inferences must be properly drawn and reasonable. Mr. Justice Appeal reminded us all what Lady Hale had said in the Petrodel judgment. The court is entitled to draw such inferences as can be properly drawn from all the available material, including what has been disclosed, judicial experience of what is likely to have been concealed, and inherent probabilities. The court is entitled, in appropriate cases, to infer that the resources are sufficient or such that the proposed award does represent a fair outcome. The aim is to prevent a cheat's charter, but the court should not jump to conclusions as to the extent of undisclosed wealth simply because of some non-disclosure. The court must be astute to ensure that the non-disclosure does not obtain a better outcome than which would have been ordered if they had complied with their disclosure obligations. I suppose the whole point of that particular judgment is you can reach a point where you're not going to get any more disclosure from the other side. And thrashing around with orders for specific disclosure and schedules of deficiencies may not necessarily be the most cost-effective, proportionate, or indeed sensible course you take when inferences might be properly sought instead. Same case, MK and SK, deals with, in a nutshell, the whole issue of trusts. A reminder from Mr. Justice Peel that Charman and Charman is the key point about this. Is the trustee likely to advance the capital immediately or in the foreseeable future? The court must bring a judicious mixture of worldly realism and of respect for the legal effects of trusts, the legal duties of trustees, and in the case of offshore trusts, the jurisdictions offshore. The test is not one of control of resources, it is one of access to resources. And the court is not bound to accept the say-so of trustees, however neutral they may seem. The ordinary rule of evidence is that the court is entitled to draw adverse inferences from the absence or silence of a witness who might be expected to have material evidence to give on an issue on the action, including Jersey-based offshore trusts, for example, and there is no obligation to draw an adverse inference. The court has a discretion. The obvious relevant factors you need to take into account: what is the purpose of the trust? Who are the beneficiaries? Who are the other beneficiaries? The history of distributions, loans, the overall value, the liquidity of the trust, the relationship between trustees and beneficiaries, and the extent of cooperation of the trustees. Nothing new, but it's a handy guide to that particular conundrum when you get it. Setting aside De La Sala and De La Sala 2026, a reminder to us all: duty on the parties in financial remedy proceedings to make full and frank disclosure of all material facts to the other party in the court. A failure to do so gives the court power to set aside an order, whether made by consent or imposed. But, and there's the big but, when the absence of full and frank disclosure has led to the court making, either in contested proceedings or by consent, an order which is substantially different from the order which it would have made if such a disclosure had taken place. We're told there is an obvious analogy of the remedies for misrepresentation and non-disclosure in contract. You've got to consider whether the non-disclosure was inadvertent. But there is no presumption that it was material, and the onus is on the other party to show that proper disclosure would, on the balance of probabilities, have led to a different order. It is not sufficient if the party who deliberately perpetrated the non-disclosure establishes only that it might not have led to a different order. You can see where the judge is coming from in that case. What are you actually seeking? Who actually has the onus of responsibility to make that argument? Contempt, the long-running case of Collado. So, Mr. Justice Peel again, a reminder of the judgment of Mr. Justice Cobb, as he then was, in re Greg Hazeltine. It's all about contempt, the power of contempt, and the rationale for imposing or seeking certain consequences. We are reminded of the Supreme Court decision in Attorney General Crosland of 2021, which set out the key factors. The court should adopt an approach analogous to that in criminal cases, where the Sentencing Council's guidelines require the court to assess the seriousness of the conduct by reference to culpability and harm. The court must first consider whether a fine would be a sufficient penalty. If the contempt is so serious that only a custodial penalty would suffice, the court must impose the shortest period, due weight to mitigation, due weight to impact, such as children in the care of the adult. Bear in mind, the sanction must have a primary function of marking the disapproval and deterring others, not just coercing compliance. Exidius comes back. Richard Todd, KC, sitting as a Deputy High Court Judge in HNEN, A reminder to us all that the Financial Remedies Court is not just a rubber stamp. Ordinary contractual principles do not apply. The court, however, will not permit either party to renege save in exceptional circumstances. Reminder back to the old case of Edgar and Edgar from 1980. Formal agreements properly and fairly arrived with competent legal advice should not be displaced unless there are good and substantial grounds for concluding that an injustice will be done by holding the parties to the terms of their agreement. But, as Richard Todd set out, the accord which is reached when the parties reach an agreement will not become binding until it has the approval of the court. The court will usually make it into an order. The parties' accord is always going to be imperfect without the court's approval, and the court might refuse the bargain. So there's also reference in that case to the what are called lesser used Section 34 and Section 35 of the Matrimonial Causes Act, rather than necessarily running the classic exiguous argument. I'm going to pass over agreements which deal with Edgar and Edgar, the special care when assessing the manner in which each party's conduct affected the other in respect of a husband and wife relationship, and Radmacher. But PN and SA is Mr. Justice Cobb's digest of that issue. And I've lost it. Costs. TY and XA, Mr. Justice Cusworth reminds us all that the key authority is Azami and Basiri. I miss out the second line in each name from 2021. Rule 28.3, the general rule in financial remedy proceedings is that the court will not make an order requiring one party to pay the costs, I'm thinking about tennis now, pay the costs of another party. But, as per the FPR, in deciding what order, if any, to make, the court must have regard to any failure by a party to comply with these rules, any order of the court or practice direction, any open offer to settle, whether it was reasonable for a party to raise, pursue, or contest a particular allegation or issue, the manner in which a party has pursued or responded to the application or particular allegation, any other aspect of a party's conduct in relation to the proceedings, and the financial effect of the parties of any cost order. The court will take a broad view of conduct for the purposes of the rule and will generally conclude that to refuse openly to negotiate reasonably and responsibly will amount to conduct of which the court will consider making an order for costs. This includes needs-based cases where the applicant litigates unreasonably, resulting in the costs incurred by each party becoming disproportionate to the award. There's a neat little line here with respect to the general method by which assessment is made on a standard basis. Mr. Justice Mostyn and JM and CZ said, the standard basis, which is by far the more usual form of order made, is commonly assumed to approximate 70% of the overall cost bill. Well, in LP and MP, Mr. Justice Cusworth dealt with the question of indemnity costs. Reminded us of what was said in Cabo Concepts, civil case from 2022. The court has a wide and generous discretion in making orders about costs. An order for indemnity costs will be justified where either the conduct of the parties or other particular circumstances of the litigation or both are such to take the situation, quote, out of the norm. It was said then by Mrs. Justice Smith, it is not necessary in the case of indemnity costs for some sort of moral lack of probity or conduct deserving moral condemnation on the part of the paying party to be established. An award of indemnity costs is not penal, but compensatory. The question in all cases being what is fair and reasonable in all the circumstances of the case. And as was said by Mr. Justice Cusworth, on an indemnity assessment, one would normally expect about 90% of the actual costs to be awarded. I think we all think, in terms of indemnity costs, has been something, wow, way out there. There's got to be something absolutely gasping or gulping. Not the case. I think that's game, set and match for me. Thank you.
The lights are back, which is good, because I think it went dark. Last but not least, we have the last speaker, His Honour Judge Spinks, who is the lead judge for the Financial Remedy Court, to deliver the last speech. Thank you.
Good evening. Let me start by reassuring you all that I don't intend to go beyond the intended finish time for this conference, Lisa, which I think is about 9 p.m. Is that roughly where we are? It would be customary to start, wouldn't it, by saying thank you all for coming. I'm going to say thank you all for staying. You've spared me the indignity of talking to an empty room, an entirely empty room rather than just a partially empty room. I'll start with some thanks. I'll echo Judge Gordon Saker's thanks for the holding of this event. It's a great venue. Thank you for that. It's very comfortable and much, much cooler than it is outside. And I think that Judge Gordon Saker was proved right in her prediction at lunchtime that the afternoon talks were just as informative, helpful, and fascinating as those in the morning. They take a long time to prepare. And I can say, on behalf of all of the FR judges in Cambridgeshire, that having a single source of reference for particularly current case law, updated issues and so on that very wide spread of material that Laura and Richard covered is very, very helpful indeed. I'm going to be even shorter than I intended to be because a number of the points, it's really current issues and an update generally in FR, was covered by Richard. I look around the room and see a number of familiar faces, some of whom I haven't seen for quite some time, former instructing solicitors, occasional opponents. For those that don't know me, and following Richard's talk to keep it bang up to date, I'm going to lighten the mood very slightly by referring to AI. It's an extract that will come as news, I think, to my DFJ in particular. I recently published the judgment at the invitation of advocates in a care case, and there was a suggestion of the case descriptor, what I should actually call it. It was fact-finding, NHS trust intervening. And I wasn't entirely familiar with the process of uploading a judgment, so I sent it off, and I had an email back saying, congratulations, it's now on there and it's published. And I thought, I wonder what they did call it. There was something about Cambridgeshire County Council and a mother. So earlier this week, I Googled Judge, Spinks, Cambridgeshire, mother, judgment. And in that way that AI does, it managed to use all of those words in the answer that it gave me. And it told me this. His Honour Judge Roderick Spinks does not typically oversee child arrangements or care cases involving mothers. Sounds like some dirty ruling, doesn't it? In Cambridgeshire, while he serves as the lead financial remedies judge for a region that includes Cambridgeshire, child welfare and mother-related family cases are usually handled by the designated family judge. Bang up to date, currently Judge Gordon Saker. A couple of paragraphs on. For child-related disputes, brackets such as care orders and contact battles, it is highly likely your case is assigned to a different district or circuit judge sitting at the Cambridge Family Court. So I feel sorry now for anybody that turns up seeing that their private law dispute is listed in front of me. I'm also thankful to be given the opportunity to say a few words in FR. I'm particularly grateful because at the end of last week, I don't know whether it was automated, I had an email reminder to book my place on this conference, and I neglected to do so. So by rights, I shouldn't even be here. No doubt a thought shared by all of you right now. A couple of current issues then. Richard talked about the Financial Remedies Guide. It was published in March 2026. It's never helpful for practitioners to have the rules about bundles, about procedure and so on, protocols, in different places. And those different places previously included, didn't they, the primary principles in the FRC and the two different efficiency statements for the High Court and the County Court level. All of those, together with the rules about bundles, are now in that one document. I'm going to push my tongue firmly into my cheek when I refer to paragraph 3, as Richard did, and say it would be a good starting point to familiarise litigants in person with it. I think it would be a good start to familiarise lawyers with it. In relation to bundles, please bear in mind the page length, please bear in mind bookmarking, and the ES2, please try and avoid judicial whiplash by putting it in the same orientation as all the other pages so that I don't have to suddenly crick my neck at 90 degrees. Locally, you may or may not know, and I'm not really sure what direct impact it's going to have on you as practitioners or your clients, but all of the 6 counties in our region, you know what our region is, sort of east of the country, are being centralised in terms of their administration to Peterborough. The upside of that means that whereas there were 2 and a bit staff fully trained before, together with untrained staff in various other court centres, I've been promised, I still await, but I've been promised 9 fully trained members of staff in the FRC in Peterborough before the end of the year. There is one FRC email address. Again, please don't all get your clients to overuse it. There are hundreds of emails that go into that box every day. The other document that Richard referred to, which I'll make brief reference to, is the consultation. As he said, it's called A Fairer End to Relationships. It started on the 5th of June and finishes on the 14th of August. And so it's out there for all of you to express your views actually about how the law should now be framed. That's really what it's about. And there are 3 aspects to it in particular, two directly relevant to today. One is about financial remedies on divorce or dissolution, whether there should be increased what's called codification or codification plus. That is to say, where concepts, some of which have been developed in case law, needs, which I think is actually a Section 25 factor, but sharing, the distinction between matrimonial and non-matrimonial property to become statutory factors with their own definitions together with guidance on how to apply them. How they're going to achieve that, I don't know, without significantly reducing the amount of discretion that we have, but we await that. There is also talk about recognising what are called qualifying nuptial agreements. The second of the 3 factors is the possibility, and this has been talked about for decades, is it not, a statutory framework of rights for cohabiting peoples on separation. Again, the notion of a qualifying relationship, so not every cohabiting relationship necessarily qualifying. And even now, I say not pointedly, it's a matter for government at the end of the day, the proposal from the government is still that rights for qualifying cohabitants remain narrower than those that exist on divorce. The third area, just for your reference, as I say, it's not relevant today, is reform of the law for cohabitants, in particular on intestacy. I think otherwise it's right that I finish there. I've gone just after 1:45, but I think that makes us 4 hours and 12 minutes early. Good to see you all again. Thank you very much.
Thank you, everybody. That concludes the Local Family Justice Board Training Day. Thank you all for coming and hopefully see you next year.